Thank you. Good morning, all. This hearing is in the matter of CFI 079-2020 and is being held by way of video conference before Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by El Tamimi and Company. Lead counsel is Mrs. Zoe O'Sullivan, KC. The sixth defendant is represented by Baker Tilly Law Corporation for legal consultancy. Lead counsel is P.V. Shaheen. Thank you, Your Honor.
All right. Well, thank you. I'm sorry for that delay. Mr. Shaheen, now we have a number of applications, or you have a number of applications today.
Yes,
there is an application for permission to appeal in each of the cases, the NMC healthcare case and the UAE exchange case. And there's an application for extension of time in which to seek permission to appeal in the UAE exchange case, but not in the NMC healthcare case.
There are two applications, Your Lordship. In NMC also there is an application submitted along with the application notice for appeal. That is how
you say that there was an application for an extension of time in the NMC case, is there?
Yes, sir. I'll explain it.
Yes, please.
So shall I go first to the UAE exchange application for extension of time, Your Lordship?
I'm sorry, say that again.
The UAE exchange application for extension of time.
Yes, I have that.
Yes, Your Lordship. The appeal permission application was supposed to be submitted on 9th February, Your Lordship. And it was duly submitted on 9th February. On the date when it was last due, it was submitted properly. But the payment got delayed. What happened was some technical problems, the payment was not going through. So 10th and 11th fell on weekend, so that nothing could be done. 12th again we tried, and there were technical glitches. We were discussing with the registry, found a solution. Finally, 14th, the appellant could not pay, so the legal representatives, we paid finally. And after that, when the appeal notice came, the date was mentioned as 14 February, although we had submitted it on 9th. So the registry clarified that they consider the date on which the payment has gone through as the date, and that is why it is 14 February. We again communicated with the registry with a request to correct the date as 9th February. And finally, on 21st, we were permitted by the registry to submit an application for extension of time on the same day before 4 p.m. in seeking an extension of time because of this technical glitches. So we submitted an application accordingly on 21st itself before 4 p.m. But the original application notice for appeal, permission seeking appeal to file appeal, was submitted on 9th February. And all these correspondence have been produced before the Honorable Court. And these correspondence are all copied to the lawyers of the other side also. So absolutely no prejudice caused. Timely submission was there. Only thing that caused some problems there was a technical difficulty for the appellant to execute the payment, effect the payment to the...
Yes, Mr. Shaheen, before you come to the question of why it was not lodged on time, my question was this. I have seen there is an application notice issued on the 21st of February 2024 in the UAE Exchange Centre case for an extension of time. But I haven't seen any application for extension of time in the NMC case.
I'll explain that separately, I thought, Your Lordship, when I come to the NMC case application. Is it all right, or do you want me to explain it now?
Yes, well, first of all, can you tell me, do you say that you have made an application for extension of time for permission to appeal in the NMC healthcare case?
Yes, Your Lordship, we did.
Where is that application? I haven't seen it.
I will explain, Your Lordship. First of all, the email which we received, there was a confusion in this case, Your Lordship, because there were two cases and one judgment. And the judgment used the word consolidated hearing and issued one judgment. So the other side, the respondents counsel was saying it was not consolidated at all, but it was just a joint hearing. But the judgment in page number 2 used the word consolidated hearing and issued one judgment for both the cases. Page
Let
number
me just see. It
Yes,
says that in the judgment, does it?
yes, in the judgment, page number 2, Your Lord.
Where will I find the, let me see.
And upon hearing, this is the third one from the bottom. And upon hearing, counsel for the claimant and counsel for the defendant, that's a consolidated hearing for the claims held on 20th November 2020.
So this is in the order.
In the order, Your Lordship. So,
Oh, I see. And upon hearing counsel for the claimant and counsel for the defendants at a consolidated hearing for the claims. Well, there may be some misunderstanding here, Mr. Shaheen.
Yes, I agree, Your Lordship. There was a misunderstanding.
What it was referring to was that there was one hearing for the two
Yes.
matters, not that the two cases were consolidated.
I get it, Your Lordship. My apologies. It caused a misunderstanding. And when we submitted the appeal, the provision was there only to make one number of the CFI case. So there were two numbers we could not enter. So we entered the number of the UAE exchange case because that's a larger amount that had a third party also. NMC case, there were only two parties. Both the parties and an additional party in UAE exchange was there in the UAE exchange case. So we used that number. But if Your Lordship look at the appeal that we filed, the appeal memorandum, the skeleton arguments is for both the cases. What we submitted on 9th February was for both the cases. Later on, we were alerted by the registry that this particular appeal in the NMC case is not shown there in the registry. Then we had discussions with the registry. We found that this is the difficulty that happened. So we sought permission from the registry, and the registry ordered us to submit an extension of time application along with the appeal notice. So I made my witness statement explaining the circumstances and requesting for an extension of time because it was along with the appeal notice. So it is not separately registered. The application for extension was submitted along with the appeal notice in the NMC healthcare.
I think I understand what you're saying, Mr. Shaheen. The fact is that the application notice for an extension of time, you only filed that in CFI 043. You didn't file one in CFI 079.
Your Lordship is right because that was separately filed. Here the directions was the defendants are further reminded that the appeal notice incident dated 14th February seeking permission appeal purports to be an appeal in CFI 43 of 2021. That is the UA exchange case and CFI 079-2020. However, it appears that no appeal notice was filed in CFI 79 of 2020. That is the NMC case, Your Lordship. If the defendant wished to seek permission to appeal in CFI 79 of 2020, an appeal notice should be filed, accompanied by an extension of time to bring permission to appeal. So that's what we did. We filed an appeal notice, accompanied by an affidavit of appeal. By
Mr.
no later
Shaheen, I think we could go on for a long time doing this. It seems to me this is what happened. You were told that in effect you had not filed an appeal notice in 079. You then filed an appeal notice in 079 and an extension of time application in 043. It seems you either understood that the registry was saying to you one application for extension of time was sufficient, or you understood the rules in some way to permit you to bring an application for extension of time in 79 by only filing an application in 043. It's probably not worth me debating with you the fact that you haven't followed the rules, because I understand you to say you thought you had. I have power to permit you to make an application without filing a notice, and I think I'll proceed on the basis that you are intending to apply for an extension of time in both matters, and I will treat your failure to have filed a notice in 79 as arising from a misunderstanding as to the rules and the advice given by the registry, and I'll treat your application in 43 as being an application in both matters. All right?
Much obliged, Your Lordship. And as a matter of fact, the 43 also, Your Lordship, it's an application for extension of time in both. But there, the extension of time sought was only till 14 February, because that was the date on which the payment went through. But subsequently, we identified that though consolidated, there was a confusion.
Now tell me about this, what you call technical problem, about why the payment didn't go through. What was the problem?
It was not me directly, Your Lordship. It was the appellant directly trying to make the payment. In 2 days, they could not make it. They told us on Tuesday, that is on 13th, 14th. Immediately, I stepped in and I paid the payment. There was no problem when I made the payment. They faced some problem, and we were communicating with the registry why this payment is not showing there. And the registry said it's not showing in the system, you paid. So we paid immediately. But then what happened, the appeal notice got dated 14/2 instead of the date on which we filed was 9/2. So we again communicated with the registry.
Again, Mr. Shaheen, it's probably not worth the time to debate the matter. The registry, in my view, are correct.
Yes,
that the proper time for putting on the notice is the time after the payment has been made and the form issues. But I understand you to have submitted that your instructors were attempting to make the payment, but for whatever errors arose, they failed to do that, but eventually it was done on the 14th. I understand.
Because we were communicating with the registry on a daily or hourly basis in order to resolve the problems. They understood what exactly we were facing. So that is why they gave us the permission, and we followed that permission strictly, submitted on the same date.
All right. I understand that, and I'll ask anything further if and when, after I've heard from Ms. O'Sullivan, if there's anything arising from what she says about that, I'll permit you to address me further on that. Otherwise, I think we might proceed now with your applications for permission to appeal.
Yes, Your Lordship. Much obliged.
All right. Yes, well, it's for you now to make your submissions in support of your application for permission to appeal. Yes.
I thought.
Are you on mute? That's better.
I'll go ahead, Your Lordship. So
yes,
we have
please.
Our skeleton arguments also in details. I don't want to repeat everything, Your Lordship. I would rather take the judgment. Your Lordship has written a very detailed judgment, 61 pages, giving all the reasons. So it makes more sense to me to look into the judgment, go through that. Only request is, my humble request is, Your Lordship, I may be given sufficient time to go through it because it's 61 pages. I have to take one by one.
Well, within reason, I'll permit you to use your time as you see fit, but the permission to appeal is based on the grounds of appeal that you have put in your notice. And unless you have you seek and obtain leave permission to amend those grounds, you are confined to the grounds of appeal set out in your notice of appeal. So the reason I say that is that I don't see any purpose in, for example, going through the judgment and pointing to some error that you see in the judgment if it is not one of the grounds of appeal, because it is only those grounds of appeal on which you have brought these applications.
100% right, Your Lordship. I'll completely restrict myself to the grounds of appeal, which are again written there. But at the same time, it's not about pointing errors in the judgment, Your Lordship. It's only a different way of looking at it, an interpretation.
Okay.
So the immediate judgment principles, Your Lordship, which is in judgment page number 8.
Sorry, now which bundle are you looking at?
It is page number 18, I believe, in the bundle produced by the respondent. I'm looking at the judgment.
Mr. Shaheen, you have filed a case bundle in each
Yes,
of the two cases.
Yes,
For example, if I go to the UAE exchange case, CFI 043 of 2021, you filed a case bundle, and the reasons are there. They start, if I can find it, in that case bundle, starts at page 126 in the bundle.
Yes, Your Lordship.
Now that's what I'm looking at. I can go down if you want to give me, if you find it easier to work on the judgment page number, I can probably work off that as well.
Yes, sir. The judgment page number is page number 8, Your Lordship.
Number 8. All right.
Page number.
So that is page 133 in the bundle. Yes. And we've there got the immediate judgment principles. Is that what you're referring to?
Yes, Your Lordship.
Yes.
The 21 subclause 1, the defendant has a realistic as opposed to a fanciful prospect of success. So there my submission is, Your Lordship, we have a realistic probability for success, and I will explain it on the way when I am explaining the points of that. And some degree of conviction and not merely argue. That again goes with the same principle, Your Lordship. And avoiding a mini trial, Your Lordship. Here I was looking for the definition of mini trial. I could not get anything solid, but I found some references in a judgment, Bank of Baroda versus Dr. Shetty. And there some references are made to, if we go further into this one, it may amount to a mini trial. So a mini trial discussing elaborately on the witness statements or discussing elaborately on the points of law raised, I would call it a mini trial, Your Lordship. Not just examination of witnesses by cross-examination. The trial includes everything. Now, this does not mean the court must take everything that a party says. So this is point number 4 in the next page, page number 134. So here, what happened is whatever is stated in the witness statement coming from the respondent side have been taken for granted. It is all approved. This is my grievance there, Your Lordship. The court should avoid being drawn into an attempt to resolve those conflict facts which are normally resolved by a trial. So here I will elaborate the point later on, but my point here is, Your Lordship, the signature, when the defendant, I mean the appellant here, Dr. Shetty says, I don't remember to have signed a personal guarantee. This is the statement. When I quoted it in my affidavit, witness statement, I said Dr. Shetty said he did not sign the paper. But in fact, Your Lordship has also made the same statement in the judgment, at least in 5 different places. The difference is that Dr. Shetty did not sign the personal guarantee because don't remember to have signed. This is just a choice of words, I believe, Your Lordship.
No, I'm sorry, Mr. Shaheen. I have taken that as being 2 quite different statements. For somebody to say, I did not sign the document is a very different statement from, I do not remember signing the document.
Yes,
where somebody says, I do not remember signing it, that means they might or might not have signed it, but they don't have any recollection of it. It is not the same thing as denying that he signed it.
I hear Your Lordship and invite Your Lordship's kind attention to some of the provisions in the judgment, Your Lordship, how Your Lordship has treated it. If Your Lordship may please look at paragraph number 30, subclause A.
30.
Yes.
Yes.
Mr. Shetty advances several contentions in opposition to the claimant's application for immediate judgment. And
Yes.
then it stated A, Mr. Shetty did not sign the NMC guarantee. His signature on the guarantee has been forged or misplaced. This is the way your lordship took it. In the defense statement, what is stated is, I don't remember to have signed.
No, I'm sorry, Mr. Shaheen. I must draw a distinction here. What is being said in paragraph 30, subparagraph A, is not a statement of what was the evidence before the court, but that is a statement of the arguments that were made by counsel before the court. So in saying that Mr. Shetty advanced the contention that he did not sign the guarantee, I was not saying there that Mr. Shetty had given any evidence that he had not signed it. He did not say, I'm not saying there that he said that in a defence verified by a statement of truth or by a witness statement, or indeed by in any all I am saying there is that at the hearing of the application, through his counsel, that's what was said on his behalf. That's all.
I note your lordship. And in the defense statement, which is verified by Dr. Shetty himself, he signed, and there is a verification at the end. He has stated that he doesn't remember. But when it comes to how the defense is elaborated and quoted in the judgment, and as I put it also, which led your lordship to make this statement, understand that, is that he did not sign. So he does see, it was something which happened allegedly in the year 2010. And we are in 2023-24 now when this trial is going on. After 13, 14 years, a person, a multi-billionaire like Dr. Shetty, with an empire of organizations under him, he would always be a bit cautious in what he's saying. He doesn't remember what he signed yesterday because there are hundreds or thousands of papers he's signing every day. So he made that cautious statement, your lordship, in the interest of honesty also, that I don't remember to have signed this paper. And he pointed out a possibility. Somebody might have forged. It could even be one of the members in our management team. He even said that. But it is just one possibility which he highlighted. He did not definitely pinpoint and say that it is forged by somebody from the management team. He said one possibility is that somebody could have cheated the bank from our own team here. Okay, because they were caught doing several criminal acts like this, and they have all absconded from the country, and they are at last not being caught. International arrest warrants have been issued against them. So that is why he made the cautious statement. But end of the day, his point is that this is not, I did not sign this. Means I did not accept or give this personal guarantee to the bank. This is what he's meaning to say. And in this context, your lordship, there are other places also. This paragraph number 22 of your lordship's judgment. Paragraph number 22 previously. When your lordship quoted that argument, in each case, the principal issue is whether Mr. Shetty and Binay signed the guarantees. That's the principal issue here. But the way it was presented in the defense statement, I fully agree with your lordship. He said this, and that's all he could have ever said. He cannot make an assertive statement more than that. And he said, I can only rely on an expert witness confirming that it is my signature. And he requested for appointment of an expert witness. He did verify, but he did not go through the veracity of the signature by itself. But he pointed out the high probability of the signature on a page being misused. And there are 15 pages almost in the personal guarantee. Only the last page, and God knows whether it was really the last page or it was a 2-page guarantee given for something else, maybe for the same party also. But we don't know how many pages could have been removed or replaced. Multiple times it have been removed and stapled. And your lordship mentioned in the judgment, it could be for copying and restapling it would have been done. No such statement is made by the respondent, your lordship. No such statement is made by the respondent. So suppose if there are few pages like this, which are not stapled, and one signature
where is the statement in the judgment about restapling?
It is there.
Take me to that.
I will show that. I highlighted it here. Paragraph number 83.
Yes.
As to point 5, the most logical explanation is that the pages of the document have been taken apart to be copied and then restapled. But in any event, that the pages of the document have been unstapled and restapled multiple times adds no support to the speculation that the last page was added to the document. This is what your lordship stated.
Yes. So there are two parts to that, Mr. Shaheen.
Yes, your lordship.
The first part of that statement is the most logical explanation is the document has been taken apart and copied and then restapled. As you say, I don't think that there was any evidence that that had happened. That is simply a statement that, looking at it as a matter of practicality, that's probably the most likely. But if you go on and read the rest of the sentence, it's saying, but it doesn't matter, because it says, but in any event, that the pages of the document have been restapled and have been unstapled and restapled many times adds no support to the speculation that the last page was added to the document. For the simple reason, if you want to just add a page to a document, you don't have to unstaple it, restaple it. The fact that the document has been unstapled and restapled tells you nothing about whether it originally had that back page on it or not.
No page.
In any event, it's simply saying that I gave no weight to that particular factor.
Your lordship had given further explanations to that point. Your lordship had come to that. But here, on this particular aspect, I beg to differ with your lordship, because I cannot either confirm that it is the same document which, if at all, arguably signed by Dr. Shetty, it is still the same document. I have no conclusive proof to that effect.
All right.
To assume that it is the same document, that's also a speculation. Because the probability is that when you removed and restapled, you could have missed a page, you could have added a page, multiple things could have happened in between. It could have been deliberate by some of the people in the office of Dr. Shetty himself also. I mean, the borrower himself.
Except I've got sworn evidence from a witness who says that he saw Mr. Shetty sign the document.
Yes, that statement is there, and I'm considering them as self-serving testimonies of the bank. For example, suppose some anomaly had happened. An adjustment had happened between some of the officers of the bank or the officers of the borrower. Then the only possibility to cover up is that witness statement. Nothing else can be done. And there is no proof given to that effect. Now, your lordship. Now, 76, 77, and 78, your lordship, on the same page of the judgment.
Yes.
The lordship is saying point 1 of Mr. Alba's discrepancies is irrelevant. There is no evidence that the claimant's usual practice at the time was to execute guarantees on a letterhead. The absence of a letterhead offers no support to the misplaced page speculation. It is just the expert estate absence of a letterhead. It was all plain white papers. Anybody can add, anybody can replace whatever is possible. If your lordship wants to call it a speculation, such a speculation is possible. When a speculation is possible, doesn't amount to conclusive proof. That's the only.
But they could, Mr. Shaheen, they could have, if they wanted to do that, they could have just as easily done it with a letterhead. It really takes us nowhere.
There were certainly 110 better ways to do it, your lordship. Doesn't mean that we justify what has happened.
All right.
Your lordship. Then 77, in the absence of evidence that the claimant's usual practice at the time was to number documents, point 2 similarly offers no support to Mr. Alba's speculation. Again, there is a possibility for a speculation. When a possibility for speculation exists, it is not conclusively proven. 78, your lordship. Again, in the absence of evidence that claimant's usual practice at that time was to have Each signatory signed each page. Point 3 offers no support to Mr. Alba's speculation. But here, God is great. If I may invite your Lordship's kind attention to paragraph number 234 in the judgment. 234. In page number 44 of the judgment, Your Lordship. It reads,
Yes, I have that.
case, UHH case. The second guarantee bears the same signature on the execution page and on each page as the first guarantee. So that is the usual practice, Your Lordship. I would have had no access to any other guarantee if these two cases were not consolidated here in Your Lordship. Many aspects which Your Lordship has found rightly that I'm not able to prove, I'm not able to dispute, the defendant could not challenge it because the borrower is not in the picture, Your Lordship. I have no access to their document. The company is in administration. I'm a third party guarantor. So this one, Your Lordship, the question which Your Lordship rightly raised in 78 is completely answered in paragraph 234 of Your Lordship's own judgment. Your Lordship. It's because it's two different cases combined, we got this opportunity. That's why I said God is great. And in paragraph 87, Your Lordship, sorry, I'm going here and there, I believe now. Again, it's regarding the signature, so it's better that we discuss it now, Your Lordship. This is 144 page number 19 of the judgment, 87. A summary judgment application should not be a mini trial. We all agree that. However, the court may and should dispose of issues that depend on factual assertions that are of no substance. It's not that of no substance, Your Lordship. Somebody is saying directly or indirectly, I did not sign or I don't remember to have signed. This has happened. And the possibility of that signature being attached to something else, there is a speculation possible. So stapling, unstapling, restapling, this is adding more doubts to that. Plus the usual practice, I already pointed out here, Your Lordship, in 234. In the other case, it was to sign all the pages. And I've been known as a banker's lawyer. I was representing 17 banks regularly for 20 years. I have never seen a guarantee which is not signed on all pages. As a legal consultant of the bank, I used to insist that it has to be signed on all pages. Otherwise, this argument will come. And there is a possibility that somebody may replace the page also. Now, this is such a case. Unfortunately, I beg to differ. This is not such a case, Your Lordship. It's not so simple. The issue whether Mr. Shetty signed the NMC guarantee is not a question of weighing complete evidence. I agree, Your Lordship. I don't have to prove. I have no burden of proof on me. I would have been obliged to prove that he did not sign if I was seeking an immediate judgment dismissal of the bank's claim, which I did not do. I did not do that. My client has honestly stated, I don't remember to have signed this. So it is only an expert report which we can rely on. An expert report has created these speculations in the air. So it's not conclusively proven. Burden of proof is heavily on the applicant for immediate judgment, which is the bank in this case. Now, there is no evidence of substance that Mr. Shetty did not sign the NMC guarantee. So it's not, when we say signed, Your Lordship, what we are in fact challenging is the authenticity of the document. I've used that word many times in my arguments, every word, authenticity. And when you look at Black's Law Dictionary, the word authenticity is defined in such a way that it has to prove that that document is genuine. It has to prove that it is from a proper origin. It is genuine. This is how it is defined, the word authenticity. So just because the signature appears on one page, other pages are not signed, loose pages. One is stapled, unstapled, restapled. I would comfortably call it loose pages. Loose pages, one signature signed doesn't bind me to all other pages which are along. Either, see, why do we do it, Your Lordship? When we sign a document before the notary public, how do they staple it? They put a thread nicely there, then across the page, and there is a stamp, a 3D stamp, an embossed stamp on it, where anybody touches that string, it will be seen. So it cannot be tampered. This is the practice, and especially this case, Your Lordship, the amounts involved are humongous. 35 million, 45 million dollars is not a small case of somebody taking a personal loan or car loan here. This is a guarantee, one person individual. He is tying himself to the liability of a giant corporate, which is taking such a huge amount as a facility. So where is the seriousness on the part of the bank? If they wanted to do it properly, certainly this is not the way. Probably NMC, New Medical Center, and UAS Exchange Center were of such good reputation at that time in 2010, 2015, and Dr. Shetty's stature in the society at that time, probably that prompted them to go a bit relaxed. They did not take care of it. And when somebody is not careful, mindful about their procedural checklist to be followed properly, there are high probabilities that other people could have taken advantage also. They want a personal guarantee. Dr. Shetty is not available. Somebody in the office just puts papers together, one signature, go. I'm not saying that this is the only possibility. I'm saying there is one possibility. The bank could have been taken for a ride at that time. Somebody from the borrower is not the guarantor who should be punished for that. And afterwards, the witness statements coming up, why I say the bank's officers, senior officers have no choice because they have verified that signature afterwards. They have to bring some sort of evidence to say that everything was done properly. We have criminal cases going on where I'm defending some of the people where verified stamp was put by the bank's officer and it was proven the signature is forged. So such things do happen, especially with large business houses in the private sector, just out of the respect and the relationship the bank's officers have for the borrower's side. Everybody is given targets. When the market is going down, also bank's targets go up. So they try to match. This is what has happened, Your Lordship. Otherwise, I'm jumping to another point, but I have to say this to complete my argument here, Your Lordship. Please bear with me. UAE exchange case, Your Lordship, Muddy Waters report. Your Lordship has mentioned in the judgment, there is nothing to prove that the bank was aware of it. I would be very surprised if the bank says that. The bank was calling back the facilities of NMC mainly because of this report and what happened to the entire empire of NMC and UAE exchange. It came sometime in November, December in 2023. Sorry, the year is different. 2019, I believe. Next year, February, March, also the bank was enhancing the facility, giving more money to the borrower. Whereas entire credibility of that organization has gone into the dustbin. So despite that, the bank is giving facilities. Why it's a concern for the guarantor, Your Lordship? When a guarantor, suppose now this is without prejudice, Your Lordship, suppose one guarantor has signed a guarantee. What would the guarantor expect from the lending bank? Due compliance with the procedure, all the regulatory laws, whatever is required for consumer protection, the bank will do its job properly is the assumption naturally all of us carry when we deal with the banking institution. And when a guarantor is signing, putting himself in that liability, he expects the bank, which is considered to be an expert by itself in the relevant field, by all books, treaties, they call the bank the expert. And when they do such things, despite the credibility is completely gone, at a time when the facility is supposed to be recalled, enhancing the facility and giving another $35 million. This is what happened. That's the way things have been handled, Your Lordship. So when I come back to the signature issue once more, the way that the signature, the expert did not verify whether the signature itself, what is seen on that page is authentic or not, what Your Lordship found in the judgment is true. I cannot deny that. This is a fact. But in a previous case, Bank of Baroda case, I have produced the judgment before the Honorable Court, where our application to reject the immediate application, our opposition was accepted. The immediate judgment application was rejected in March 2023. The year I'm not sure. It was in March. Our judgment was in February. After this, they have referred. In fact, honorable judges referred to Your Lordship's judgment in various places. So there, what happened, Your Lordship? The signature, same problems existed there. stapling, restapling, all this, the possibility, speculation, whatever we call it, it was there. And it was decided that it's not a case fit for immediate judgment. I have produced the judgment here. And in that case, one more thing happened additionally. On that particular case, Your Lordship, when the expert was permitted to review the documents, verify the original documents, I was personally present. Because it so happened that the claimant's counsel's office was the place where it was supposed to be. Afterwards, it was that we were going there. We were giving hardly few hours with the document in that place. And the expert was asked to verify and return the papers immediately. So there was a constraint. After that, we several times requested for the documents again, it was not coming. So there was a lack of cooperation also there. Additionally, I don't want to hide any fact, it was there in that case. But in this case also, Your Lordship, suppose a signature has to be compared with the original signature under a microscope, it has to be taken to the lab. We all know that it has to be taken to the forensic lab. That opportunity was not given, Your Lordship. Here it was verified at the counsel office, few hours, and this is what the expert could do.
Well,
so in the
Mr. Shaheen, is there any evidence that he asked to take the document away to a lab and a microscope and was refused to do that?
In this case, no, Your Lordship.
No.
Lordship.
All right. Well, it's not relevant then.
It is discussed in the other case. I'm not hiding. I'm telling the whole fact about the other case in this one also. I don't want to play actions. That's all.
Okay.
So, Your Lordship, such an examination is required. Why the expert is not opined that a signature itself is full? Why he didn't go to that level? Because that was the time allowed. That was all that could have been done because of, Your Lordship, if you look at it, the proper lawsuit comes on the first day. They did not first come with an immediate judgment application. And then the discussions went on. We submitted defense statement. And then there was a case management conference also scheduled in UA exchange case. At that time, suddenly comes the immediate judgment application and the case management conference was vacated. And then it goes to immediate judgment. So there was no time. There was a time problem also there. On top of that, Your Lordship, if Your Lordship look at it closely, there was 2 stay applications also. In each case, in an MC application and a new exchange case, there were stay applications. And the stay applications were submitted for very definite reasons. Because what is my liability, Your Lordship, as a guarantor? Whether you call it indemnity or guarantee or whatever, what am I supposed to pay to the bank? The amount due to the bank from the borrower under the facility which I'm guaranteeing. How the bank has proven here, how is that amount determined? By a self-serving document the bank produces and we all believe it, especially in the absence of the borrower. The case against the borrower is stayed here. The case against the corporate guarantors has stayed here. What is the hurry to jump and catch the personal guarantor when the liability of the borrower is not proven? Whether the borrower, something happens, illegality, or the whole thing becomes void, indemnity will kick in. I understand your question. That's a different issue. Here I'm talking about determination of the liability. Why would we are treating all the people who are coming in front of your Lordship equal, whether it's a bank or an individual or a poor man or a rich man, we give equal treatment as courts. I'm an officer of the court. My duty is to ensure that the court arrives at the right conclusion. So here, when equal treatment is given, suppose I'm giving a statement before the honorable court, the court is not going to believe that it is zero liability now. Suppose the defendant does that. Same approach should be taken to the bank. Bank gives a statement. We don't have to believe that the amount is true. Some step has to be taken. And when your Lordship asked me this question during the hearing we had previously, I said the bank should have applied for an expert examination. But at that time, your Lordship told me in DIFC court, no possible. Okay. But actually, RDC rules do permit.
I'm sorry, say that again. What did I tell you you couldn't do?
Yes, Your Lordship. When during the previous hearing, when we had the session, Your Lordship, how do you expect the bank to prove the liability? Okay. So I was saying the bank should have asked for an expert, as a court to appoint an expert and submit a report like it is done in the mainland courts here. That's the way to go. Your Lordship said, no, it's not possible in the DIFC code, and I did not answer that at that time.
Well,
But
I don't have the transcript, but I'm surprised if I would have said that it's not possible for the court to appoint an expert. The court can appoint an expert,
I don't
but
have to.
there's no obligation or requirement for the court to appoint an expert. And indeed, in the ordinary course, in adversarial proceedings, the role, it is for the party, each party to produce its evidence, and
Very
it's
well
for
said.
each party to bring forward expert evidence if it wishes to rely upon it.
100% agreed, Your Lordship. It's not for the court to do the job of the claimant. It is for the
Right.
claimant to apply to the court for an expert report and prove its case, especially in the case of an immediate judgment. They have the burden of proof heavily on them. They have to prove their case. Their own statement is not enough. Many places, Your Lordship said, there is no evidence to the contrary. They are saying this amount is due. There is no evidence saying the borrower has paid the money. How do I say that? If I say that the borrower has paid the money or the amount is not true, I am lying in front of the court because I have no idea. I'm an outsider now. I have no access to the documents of the borrower. It's in administration for several years. So when the borrower is shut, it's not in the court. When there is a stay of the proceedings and there is even a standstill agreement against, in the case of UAE exchange, I don't know the terms of the standstill agreement. Amount is not due for payment is my humble submission here.
All
And the
right.
amount is not determined is also the case. Very strong case I have here, Your Lordship.
Now, Mr. Shaheen, can you help me, please?
Yes, sir.
The submissions you've been making so far, which ground or grounds of appeal do they go to?
First one is regarding the signature, Your Lordship.
Well, which grounds of appeal go to the signature? On your, the grounds of appeal in the appeal notice are put in rather general terms.
Yes, Your
The
Lordship.
submissions that you filed, you take it up in ground one. You talk about the signature. That's ground one, all appears to be to do with the NMC healthcare case. Is that right? Ground one?
Just to clarify, Your Lordship, the ground one, the order has misinterpreted the requirements for the dismissal of the immediate judgment application, mistake of law. That is how it is presented in Telangana.
I'm sorry, did you say that applies to both cases or just to the NMC healthcare case?
Okay, so the first one, the order has misinterpreted the requirements for the dismissal of the immediate judgment applications. This is the first ground, Your Lordship, which I just touched upon in the introduction, that the first part, citing, and we have cited the judgment issued by Honorable Chief Justice in Mazrui case, Your Lordship. For that, I'll just take few sentences from that and just repeat that part, Your Lordship.
All right.
It is true that at this stage, the appellant is not obliged to produce evidence the guarantee is in fact forced. I'm not obliged to produce evidence that the guarantee is in fact forced. I just have to show a possibility. That's it. But the must.
Well,
but
well, I'm sorry, Mr. Shaheen. I don't think it's right to say you just have to show a possibility. You have to show, or I have to determine whether your defense has a real prospect of success. I mean, possibility can mean, has a range of meanings. You might be familiar with the expression, all things in life are possible, all things in life are uncertain except death and taxes. Now,
not a
something might be possible, but that doesn't mean that there is a real prospect of the defense succeeding.
The word is a real prospect, Your Lordship. The real prospect, not a fancy.
Real prospect, yes.
Now, it is true at this stage, the appellant is not obliged to produce evidence that the guarantee is in fact forced, which I cannot do, need not do. But he must at least adduce something, some ground, basis, or fact that can enable the court to conclude that there is sufficient basis to the claim that forgery had taken place. This is what I did by appointing an expert, pointing out by the word forgery again, just like the word authenticity. I don't mean that the signature itself. I mean that the authenticity of the document. Forgery can happen in various ways by changing a page also. The best and easiest method the appellant could have adopted, of course, would have been for him to get a handwriting expert to confirm the inauthenticity of his signature. This is to confirm the inauthenticity of signature. This is where I went by Black's Law Dictionary. What is the meaning of the word authenticity? It is not just the signature, whether it is proper or not. It is the genuineness of the document, the origin of the document, the reliability of the document, etc. What is stated there. As a standard and rather straightforward procedure, at the very least, I would have expected the appellant to produce some evidence to substantiate the possibility that his signature was forged. The word used is possibility, that his signature was forged, or even some demonstration of his conviction in the forgery allegation. We have done it, Your Lordship. The possibility we have shown, the real prospects we have shown. The expert report is what the Honorable Chief Justice said. We have done that as well. And finally, what His Lordship says is a strong statement to that effect with sufficient explanation may have sufficed. It's a very strong statement when someone says, I don't remember have signed this document. It's an honest denial. It's not a denial for the sake of denial, just like that, a man who will say whatever he wants. No, it's an honest way of denying a document. A strong statement to that effect with sufficient explanation may have sufficed. Such steps would not have been very difficult. We have taken the difficult path of appointing the experts and doing whatever was possible during that time. And this is where, Your Lordship, I was about to say about the stay applications. We had submitted stay applications. When I submit stay application, am I supposed to submit other interlocutory applications in between? That kills my stay application, right, Your Lordship? So the stay applications were pending, but despite that, by abundant caution, in one case, I submitted an application for appointment of expert and verification of the document, and which has brought to light the real prospect or possibility of the pages would have been changed. This is not the genuine document. This is not an authentic document, which is foolproof. It's not conclusively proven that these 15 pages have been accepted. And even the usual practice, which the expert did not say, but Your Lordship mentioned rightly in the judgment, what was the usual practice? We are extremely lucky to have the two cases together. So I could show to the Honorable Court the usual practice is to sign all pages and number it, which is not the case in this one. Then in paragraph 38 of Masrui case, the Honorable Court clearly states that the defendant is not obliged to produce evidence that guarantees in fact. So I've explained it in my skeleton arguments, Your Lordship. I don't want to take a lot of time repeating it. Now, the findings of the expert, Your Lordship, the document was not numbered. None of the pages contain the stamp of the respondent. None of the pages, Your Lordship. The signature of Mr. B.R. Shetty is provided separately on a paper, which is stapled as the last page of the document. This is what he wrote. But as Your Lordship rightly pointed out, there's another signature in that page. That signature could have been subsequently put also. We don't know. Or maybe the same person, I'm not going to make any allegations against the bank's officer, somebody from the office of the borrower. The pages have been restapled numerous times, and he has produced photographs also in the report. It would be very easy to insert or delete any sheet as long as the pages are not numbered. Pages not numbered is, I wouldn't expect in any serious document. Look at how we have numbered the pages in the judgment, how we have numbered the pages in the skeleton arguments, how the paragraphs are numbered. Any serious document will carry page numbers, Your Lordship. And signature on all pages is a must. It need not be said in the law. It is a matter of evidence. Suppose the burden of proof is on me, I would have been in trouble if I have not signed all pages, or the other, my counterparty has not signed all pages. It would be difficult for me to prove on loose pages by taking signature on one page and saying all other pages are binding on another party because he signed on one page. That will be too much of a speculation the other way. It's not a conclusive proof. So the possibility is also used in Masrui case, Your Honor. So I have highlighted and underlined it in my skeleton argument. Now, the appointment of expert I have highlighted in paragraph 10 of my skeleton argument, RDC 31.29. This is, I would say, the least that the claimant should have done in a case where the borrower is not heard. The borrower is not present. He has they got all the cases with the consent of the claimant, the cases are stayed against the borrower. And there is a standstill agreement in one of the cases. They only want to catch the guarantor and without proving what exactly is the liability of the borrower. If the borrower, there is something wrong in the facility agreement that is void also, I will be liable. But it has to be proven the borrower's liability. What I have guaranteed is the borrower's liability. That I'll come through that. Now the ground 2, the order has not considered the requirement for a trial in the UA exchange case. This is similar set of facts. Only difference is, your lordship, in this case, our application to appoint an expert has come after the judgment. Again, the issue we were facing in that was the sudden application for immediate judgment and suddenly cancellation of the case management conference, and our application for stay were pending, and everything went together into, if I may call it, a mini trial, and we had a consolidated hearing. This is what happened. But when the consolidated hearing is happening, the evidence which is produced in one case should definitely throw some light for the case, the other case also. So here, the chances of forgery, chances of manipulation is established. It's a speculation, but speculation goes against conclusive proof, is my argument. It's not conclusively proven. So the same principles apply to UA exchange case also. Now, the third ground which we have stated is misinterpreted the application of Article 8 of the Difc law number 3 of 2004. This is regarding application of UAE law. On one part, your lordship has applied UAE law. I don't have any grievance, even if there is something as an overstatement in my skeleton argument, I apologize for that. That was not the intention. There a lack of clarity was there because certain aspects your lordship put it as regulatory points, which I believe is consumer protection. Because the law, the banking law, if I may take that example, the banking law is a federal law, your lordship. It's a federal law passed by the UAE federal government. So it's not by the central bank. It's not a regulatory law by the central bank to govern or regulate the financial institutions under them. It's a federal law. And in the federal law, those provisions relating to security. Of course, your lordship, the court in England, High Court in England, another case in the IFC, even we ourselves have faced a lot of challenges due to the translation from Arabic to English. Even my Arabic is very mediocre, it's not up to the level. But I had a discussion with the Arabic lawyers in our office here, and the word used is amana. Amana means collateral or security. If it was referring to a guarantee, the word used ought to have been kafala. Kafala means to guarantee. But the word used is amana, translated as guarantee. Every word, when we look at it, the translation comes as guarantee, but it's not guarantee. It's a real security. So what the federal law has actually intended in Arabic language is sufficient security. Don't give merely based on somebody's guarantee. It has to be sufficiently securitized. And when a bank violates this mandatory provision of the UAE federal law, the guarantor suffers, your lordship. The guarantor is put to suffer because the bank did this, the entire liability is coming on the guarantor. If they had sufficiently securitized and taken proper security in compliance with applicable law, the guarantor who is sitting in the mainland, he has no presence in the DIFC. The borrower has no presence in the DIFC. But the guarantee in the NMC case at least is clearly stated that governing law is the UAE law. And UAE law includes all UAE laws, including this particular federal law. And your lordship has rightly examined it in the judgment, the opt-in clause. Because of that, this law is applied. Otherwise, if it was a regulatory thing, your lordship said, I will not consider it. If it was a regulatory thing, I agree with your lordship, we should not consider it. Because regulation for DIFC entities should come from DFSA, not from the UAE Central Bank. But here, it is a federal law, your lordship, and that chapter 6, which your lordship quoted in the judgment, the heading is consumer protection, your lordship. It's not under the provisions what the bank should do for getting themselves organized in a better way. It's coming under the head consumer protection. And then it is stating this. There are judgments, your lordship, on various grounds from Abu Dhabi court and Dubai court also. But we all know This is a civil law system. There is no system of binding precedents as such. Judgments are coming for and against. Some judgments are saying it has retrospective effect. Some judgments are saying it has no retrospective effect. Another judgment saying only for sole proprietorship, not for corporations. But finally, because of this confusion, the ministry, the concerned ministry, which is passing these laws, had to give a clarification. And the clarification is very clear, which is stating that it applies to all corporations, it has retrospective effect, and all courts should follow this. So who is in a better position than the ministry itself to give such a clarification? But since that ministry is situated in Abu Dhabi, the Dubai court did not want to follow that. But our borrower, our guarantor are all based in Abu Dhabi. So we should not have any problem in following that ministerial order, which is clarifying the intention, purpose of the legislature. Who is the best person to clarify the intention? The legislature itself. That's what we learn in interpretation of statutes. The paramount consideration is always to be given to the intention of the legislature, the legislative decree, the intention of the legislature who passed it. So they have clarified, it applies. Now, Article 112 of the Constitution, UAE Constitution, some judgment referred to that and said all laws should have only prospective effect, never retrospective effect. But unless the law says otherwise, is what the Constitution reads. Unless the particular law says otherwise, it is there. I have taken this argument in other cases that came against me, and there was a retrospective effect.
Where in the law does it say otherwise?
Can you take that Article 112 of the Constitution? I will produce it, Your Lordship. I'll show it to Your Lordship.
No, I understand the Constitution says that.
Yeah,
but
I understood.
Where does the law that we're concerned with say that it operates retrospectively?
There was a confusion whether the law says that or not. And this was addressed by the ministry and confirmed that.
Where is the confusion? What is it in the law that can give rise to the possibility that it applies retrospectively? What is it in the law? What is said in the law which could give rise to the meaning that it operates retrospectively?
I'll explain, Your Lordship. The confusion came from the conflicting judgments from various courts, same courts in Abu Dhabi. So the ministry stepped in and clarified that it is retrospective. It is going to affect everybody. So that's how it happened. So the concerned party has clarified that it has got retrospective effect. So thereby that we can assume that the law itself was intended to be retrospective, right? That's how the interpretation of statutes teaches us. And plus, it is talking about security. It clarified that it applies to corporations also. Then the question comes, Your Lordship, there is another article which I cited on the commercial transaction law also, which says that the bank should take sufficient security. There, Your Lordship has raised the question to me, why am I citing this? Where is it stated that the court should not hear a case that when sufficient security is not taken? I think it was Article 490, if I remember it. Then my answer is, Your Lordship, it is this Article 121 in the UAE federal law regarding banking, which states that no lawsuit can be filed if you don't take sufficient security. We have to connect the dots, Your Lordship. Both are the UAE federal laws. I'm only pointing out, it is not just in the banking law, it is in the commercial transaction law as well, that sufficient security is a must. So the bank is violating that, the guarantor's rights are affected. The guarantor's rights are affected, and the courts, the law, banking law clearly says no lawsuit can be filed. And it's a federal law by which the guarantor is governed, the borrower is governed, and the applicable law to the NMC guarantee is also the UAE federal law. So it squarely applies. The question whether this particular law applies or not does not arise, and Your Lordship has rightly found that it applies. But the implications of it regarding the retrospective effect applying to corporation, there has been a confusion, which I beg to disagree with Your Lordship, because the ministry has clarified that it applies. Retrospectively, it applies to the corporations as well. And the correct word is security, Your Lordship, not even guarantee. I had a lot of problems with that, so I did my research and I have come to that. The word is amana. Now, application of UAE law, that is the aspect. Only place where I wanted to slightly disagree with Your Lordship was the skeleton argument is Your Lordship had pointed out the regulatory aspect. Your Lordship considered this particular law as a regulatory aspect, which I beg to differ. It is not a regulatory aspect. It's a UAE federal law which applies to everybody, and it comes under the heading consumer protection. And it also comes, the stipulation that sufficient security is a must also comes under the commercial transaction law, and the consequences are explained in this law. So it's not a regulatory issue, it's a protective issue, a protection given to the consumers. A guarantor, when signs a guarantee, assumes that the bank is the legal entity which will follow the law. And assuming that the bank is in compliance with all the applicable laws, I'm signing the guarantee. If the bank does otherwise, it is my rights which are getting prejudiced. So this is the humble submission on that regarding the application of law. The UAE exchange case is slightly different because, not slightly, very different, I must admit, because the governing law is the DIFC law. I don't want to argue otherwise, but when two cases are consolidated hearing, each one will affect the other, the findings. And there are
I'm sorry, I didn't understand that at all. Could you say that again?
I know what your lordship means. When two cases are having a consolidated hearing, the findings, applicable law, everything what your lordship has also done, discussed elaborately one case. And many times in the other case, we are referring to paragraphs in the previous findings of the other case. So that has got an overlapping effect is all what I mean to say. The applicable law also. I did not ask for consolidated hearing or joint hearing. It was the other side. So there is a possibility that when we are looking into, we cannot have watertight compartments in a consolidated hearing. That's my submission. So that's the only thing I can say, not more than that, because the applicable law is DIFC law in the UAE exchange case.
All right.
And there I have raised the issue of prudential rules. And the prudential rules have the same effect, your lordship. Prudential rules may be regulatory aspects, but DFSA's regulatory aspects of banking financial institutions squarely applies in the case of UAE exchange. And again, I raise the same contention here, your lordship. When a guarantor is signing a guarantee in favor of an institution, a financial institution which is registered in the DIFC, the guarantor expects that financial institution to comply with all the regulatory aspects of DFSA rules. The prudential rules are important there. And when the bank does not comply with the prudential rules, it doesn't have that periodical. I've explained all those articles which talks about what are the regulatory obligations of the bank periodically, not ignore everything, including the Muddy Waters report, which was the only news in UAE financial sector for those months. And the bank cannot say that I was not aware of. Impossible. They are a lender, they have the duty to know. And they have never dared to say, I did not know. The lordship only presumed that maybe they don't know, but they cannot even raise such a contention here. 100% they are supposed to know. They know definitely. And the other case, NMC case also, they have said that they knew this, the problem. And that is why they felt that the inability of the borrower to repay the facility, even though default everything is defined in such a way. So here, when the prudential rules are overlooked, the bank is not doing its duty. There is a serious suffering on the part of the guarantor too. Maybe I did not explain it properly during the previous hearing. Maybe in my skeleton arguments, your lordship rightly pointed out that I was not clear enough where am I coming to. Probably that was an oversight on my part. If that gave some difficulty, your lordship, I'm really sorry for that. But the intention was this, your lordship, to show that when a bank doesn't follow its regulatory duties, it does affect the rights of everybody who is dealing with that bank. For a borrower, it can affect. For a person who is giving a fixed deposit to the bank, it could be in danger if they are not following the regulatory issue. For a guarantor, 100% confidence and trust is placed on the bank, and the strong feeling the bank will definitely follow the regulatory procedures laid down by the prudential rules. If not, they will be taken to task by DFSA. DFSA will not allow them to function like that. But maybe nobody pointed out this to the bank, to the DFSA. Again, the fifth ground four is stated, point number 5. The order has not considered the jurisdiction under applicable law clauses of the NMC disputed personal guarantees. I think we already covered that aspect, your lordship. I don't want to repeat it. And my apologies if at all I was not entirely clear that I'm referring to that regulatory aspect which your lordship said. My point here is that This banking law, which is issued by the UAE federal government, is a UAE federal law and is not a regulatory law issued by the central bank. And these provisions which we are quoting, Article 121, which got amended subsequently, comes under the head consumer protection, which is us, whoever dealing with the bank in whatever capacity. And then, Your Lordship, point number 6 is that Article 1061, Your Lordship. Here I may have to go a little more elaborate, Your Lordship, on this one, because there is a difference. I agree with Your Lordship, because I was the counsel appearing in the Velocity Industries case as well, where I got a judgment in my favor from the Honorable Justice.
In which
Rene.
case?
Velocity Industries case, Your Lordship, where I got a judgment in my favor for my client saying that the guarantee is an all monies guarantee and cannot be enforced under UAE law. Slight difference in wordings are there, but the guarantee here is connected to the facility agreement. Is Your Lordship's point. I agree that it is connected to the facility. It's not that whatever is due from this borrower, whichever facility I guarantee, that's the all monies guarantee. That's not the way it is spelled in this particular guarantee. It is connected to the facility agreement. Then what is the purpose of this protection given under Article 1061, Your Lordship? It is the liability of the borrower should be measurable. It cannot be connected to various things. It should be either spelled out in the guarantee clearly, or it should be connected to a facility agreement, which can clearly say what exactly is the liability. Here, the first part being connected to a facility agreement is fulfilled, Your Lordship. I cannot argue otherwise. It is connected to the facility agreement. This is all arguments, Your Lordship, without prejudice that I have not signed. The authenticity of the guarantee is disputed. I'm going ahead with other points here. It's without prejudice. I just say that for the sake of my own comfort. Now, if we look at the personal guarantee, as per the definition of personal guarantee in the disputed NMC facility agreement, which I have quoted in page 15 of my skeleton arguments, Your Lordship. What is the page number? So, page number 15 of the skeleton arguments which I have presented, Your Lordship. Personal guarantee means the guarantee to be provided by the personal guarantor in favor of the lender to secure the obligations of the borrower under the finance documents. This is how, when you reach the facility agreement, this is where the personal guarantee goes, Your Lordship. And finance documents, as per the definition clause and the construction clause 1.2a subclause 6 is defined as finance documents means this agreement, which is a facility agreement, and security document, and any other document designated by the lender, and each such finance documents as amended from time to time. No control, Your Lordship. The guarantor has no visibility what all amendment can take place afterwards. And any other document designated by the lender, guarantor has no control. Guarantor has no means to know where my liability can reach in this one. What all am I guaranteeing here? So it's in the character of an all monies guarantee, although differently worded. The whole purpose of controlling the guarantor's liability, identifying it to a particular facility, limited to that, is not maintained here. And as per the construction clause 1.2 subclause A subclause 6 finance document must be interpreted as follows. This is the argument I have raised, Your Lordship. Finance document or any other agreement or instrument is a reference to that finance document or other agreement or instrument as amended, novated, supplemented, restated, or replaced, and includes any increase in, extension of, or change to any facility made available under the finance document or other agreement or instrument, and including any waiver or consent granted in respect of any term of any finance. Where does it end, Your Lordship? It is a never-ending definition. It can mean anything what the bank wants to do without the knowledge or connivance of the guarantor. Guarantor has no role in any of this what is stated in the definition of finance document. See, if this is not characterizing the personal guarantee as an all monies guarantee, what else will? This is a question. So from a bare reading of the above definition, it can be clearly understood that the term any other document implies that the amount under the disputed NMC facility agreement is subject to variation and fluctuations and is uncertain. Since the disputed NMC personal guarantee are to derive its meaning from the disputed NMC facility agreement, That's how the connection comes. More specifically, from the meaning and interpretation of the finance documents, it is apparent that prima facie, the liability under the disputed NMC personal guarantee does not fall under the purview of a specified debt that is certain and fixed. So, Your Lordship, again, am I supposed to prove all this, Your Lordship? This is all for the trial. The burden of proof is on the other side. I'm only trying my best to convince Your Lordship in my own humble way. There is a real prospect. There is something to be argued. There is something to be heard. There is something to be proven here. At least the poor defendant has tried to appoint an expert and bring something to the court. What did the claimant do? No expert, no report, no independent finding other than its own officers and their self-serving testimony. And if at all there is any element in the allegation that the guarantor is making that this guarantee is not signed by him, what else would they do to cover their own mistakes? So we don't want to make any false allegation. We have been extremely cautious. The defendant has been cautious, and I cannot be more loyal than the king making allegations against the bank. He has not done that. He only said it could be from the offices of the borrower. We are not pointing fingers at anybody. We are always doing everything with due respect, maintaining the professional ethics. Several allegations personally against me by my learned friend in their submission. In my ignorance, I did not follow. The whole procedure is made into. I don't want to name all that, and I will not go there, Your Lordship. It hurts, though. I have not done it, and I don't believe I deserve it. I never done this to anybody in my profession. So here again, Your Lordship, coming down, financial indebtedness is defined as. Again, the definition expands it further. Any indebtedness for or in respect of. Then, do your Lordship really want me to read? I think it's A to K, the documents and items.
I can see it. You don't have to read it out loud.
I don't want to waste time, Your Lordship, but the indebtedness can reach the end of the world, okay, and it can go to space also. Yeah, the way the definition is given. Now, indebtedness as per the concession clause in 12810 is stated as follows: includes any obligation, whether incurred as principal or as surety, even if that borrower incurs any liability as a surety somewhere else for the payment of the money, whether present or future, actual or contingent. Nothing is left out. Present or future, actual or contingent, that covers the world and the sky, earth and the sky. So it is in the character of an all monies guarantee. We cannot take the guarantee alone and say that the guarantee says so and so. The guarantee directly refers to the finance facility agreement, which I'm guaranteeing. And the facility agreement stretches beyond anybody's imagination. It goes farther and farther. So it is in the character of an all monies guarantee, is my humble submission, Your Lordship. Here again, a harmonious interpretation, the net debt, one more definition, means net debt. It's in page number 17 of my skeleton argument. The first paragraph on top means at any time, the aggregate amount of all obligations of the borrower for or in respect of the financial indebtedness. Financial indebtedness itself is too wide. And if it is anything for or in respect of that also will come into play, the net debt. Reduced by the bank and cash balance at the time, but so that no amount shall be included more than once. That's just a small protection given. They will not claim it twice from me. That's all. Otherwise, it covers everything under the sky, Your Lordship. This is how it is. Then one more definition, Your Lordship. It doesn't stop there. Unpaid sum means any sum due and payable, but unpaid by the borrower under the finance document. This is why. What am I guaranteeing? Unpaid sum. Where am I putting my liability? My liability with the liability of the borrower. So without determining the liability of the borrower, without determining whether that liability has been settled or not, how can I be responsible to pay that money to the bank? So this is where determination of the amount by an independent body, where I refer to the expert, the claimant ought to have taken that responsibility to get an expert appointed and submit an expert report determining exactly this is the liability. And ideally, that expert should have heard the other side also. But then the borrower is not in the book. The proceedings against the borrower has been stayed consensually. And against the other borrower, there is a standstill agreement also. So we don't know whether it is paid or not. We don't know whether there is a liability existing or not. This is all we have to just swallow it without a pinch of salt, whatever the claimant is saying. Where the law clearly says that the burden of proof is only on the claimant when it comes to the immediate judgment. It should be proven like a promissory note, if I may take an example. No other possibility, only one possibility. So it can either be by an admission or it can be by an independent determination, conclusive proof. It cannot be otherwise, Your Lordship. Now, there is an analysis which Your Lordship has done between guarantee and indemnity, Your Lordship. I'm obliged to indemnify the bank as a guarantor. So the wording is, in consideration of the bank entering into or agreeing to enter into the facility agreement with the borrowers, the guarantor hereby irrevocably and unconditionally guarantees and promises to pay on demand to the bank any and all sums of money that the borrowers are obligated to pay to the bank under the facility agreement. So where does it reach, Your Lordship? First of all, I am liable to pay only such amounts which the borrowers are obligated to pay to the bank. That obligation is not determined, is my point. First step in claiming any money against me is determine that obligation, what is that of the borrower. Then I am there. I can be sued as a primary obliger. I can be sued as a person who was whatever. I don't say that you first sue the bank, exhaust all your remedies, then come again. I did not raise this argument, Your Lordship. I said the liability has to be the obligation which I have guaranteed has to be determined. And Your Lordship said that there is no counter evidence. I understand the situation where Your Lordship is put in because claimant is saying this is due. And it is listed on this date, it was this, on this date, it was this, every day, $5,000 or something is getting added. All this is stated. But how can I deny, Your Lordship? I'm not the borrower. I'm not privy to those documents. I'm not privy to those statements of account. I have no access there. So this is an empty goalpost there. The borrower is not there and nobody is there to deny. So it doesn't mean that a third party guarantor should suffer. It has to be proven. The claimant was not prudent enough to take the necessary steps to get an expert appointed from the court to prove that this is exactly the liability so that I'm obliged to pay that. That step is not taken. So the burden of proof is not discharged. The liability is not conclusively proven. My liability as a guarantor, even assuming that I have signed the guarantee, would kick in only if that liability is proven. That's my humble submission. Bank and are obligated to pay under the agreement that the borrower has failed or omitted to pay when due in accordance with the terms of the facility agreement. We had no chance to verify, Your Lordship, neither Your Lordship nor me. We did not have any chance to verify whether such failure has happened or not. Only allegations and self-serving testimony and testimony of oral witness, the witness statements, have a right to cross-examine. Once a witness is coming to the court, it's like a chief examination. How do I know whether he is telling the truth or not? Only way is to subject him to cross-examination. And if I submit an application, most probably the court is going to allow me to cross-examine him. And that is the necessity for a trial. I need to check whether this witness is saying is true or not. See, I'll give one example here, Lordship. One officer going in 2010. He goes with a particular driver, he goes with the officer of the bank, all that, and coming here, and the timing, Dr. Shetty opening the door, all this is explained there. If I look at the time also, 10:50 a.m., it is in the register that he's leaving. Exactly 1 hour, 30 minutes, he's reaching here. He did not sign the register kept in the office from the car, Your Lordship. He has to sign it up there in the office of the bank and then take a lift, come down, catch the car, and then 1 hour, 30 minutes is impossible. 1 hour, 30 minutes is a normal running time. I'm just showing some doubts on the testimony, Your Lordship, which I can't assert unless I cross-examine him. How on earth it was possible for you to do this? Then, Your Lordship, both of them, the UAE exchange case, they are saying Mr. Sudhi Shetty, Mr. Pradeep Kumar, another person were present. 2 other persons were present, and I don't know their name. I don't remember their name. I remember seeing them. The 2010 officer, one person, Rajkumar, he says this thing. Exactly verbatim, same thing is stated in 2012 after 2 years, as if these 5 people are permanently, as statues present in that office, and they only know the 3 names of the first 3 people. Other 2 names are not known. This is copy pasted, nothing else. They have cooked up a story and they have come up with this is the only inference possible when you read such statements in the witness statement. So this is how you check the veracity or the authenticity of the witness statements in a cross-examination. They clearly remember the time, the date, everything. If I ask him about any other facility you have given in 2010, 14 years back, can you tell me the exact time and date on which you signed this document with another? They will not be able to say. So it's not.
Your Honour, Mr. Shaheen has now been making submissions for an hour and a half. I wonder if he might indicate when he's going to finish.
Can you do that, Mr. Shaheen?
Pardon me, Your Worship?
How much longer do you think you will be?
1 hour more.
Pardon?
1 hour.
Another hour?
Yes, Your Worship.
What are you going to address? You've been through all of the grounds. What are you still going to cover?
There are still few points I want to point out from the judgment, Your Lordship, just connecting the dots.
Well,
I
permit you to continue on, but I don't want you to repeat what you've already said. And you've largely been through the grounds. So let's proceed, but bear in mind, you've made your points, and I don't want you to repeat any of them. So be careful as you go through not to repeat something that you've already covered.
Definitely, Your Lordship. I'll try my best to be as precise as possible and conclude it in 30 minutes if possible.
All right.
5 minutes. And the indemnity includes, but not limited to, all costs, charges, expenses, losses, and the bank may sustain on account of any failure, omission by the borrowers to perform all or part of their obligations under the facility agreement. So there are many things to be proven against the borrower if the indemnity has to kick in. What the borrower has paid first, they should have incurred all these costs and other expenses, charges, and everything, losses, and then only the indemnity clause will kick in. It is not just automatic. I say some amount and you have to pay. That's not the way it reads. Same applies, similar contentions applies in the UA exchange. It could be taken as a combined argument, Your Lordship. Though I took the definition, it applies to other case also. Definitions of indebtedness, security documents, finance document, etc. under the UAE exchange facility agreement prove the liability of the borrower includes any future and contingent liabilities. I have raised it in paragraph number 58. I don't want to read the whole thing, but if a crux of the matter is, it is more or less similar to the other one. So all monies guarantees are not enforceable under UAE law. In the NMC case, it is directly by UAE law, governed by UAE law, and therefore 1061 should apply, Your Lordship, is my humble submission. Now, 390 and 391, Your Lordship. It's pertaining to current account. Article 390 and same provisions were there, almost verbatim, same provisions were there in the previous commercial transaction law. So they did not change. Although the law changed, the provisions remains. Current account is a contract between two persons whereby the rights and debts arising from their mutual relation turn into entries in the account to be set off between each other so that the final balance alone upon closing the account shall be a due debt. So this is the definition of what is a due debt. The current account, payment, withdrawal, credit, debit entries are made. What is due for payment? Only the final balance at the closing of the account is the definition given for a current account. So when a bank has to claim money from the guarantor, they have to prove that the current account has been closed and this amount is due. This is exactly the balance, and only then raise this claim. Now I may take Your Lordship's attention to some of the provisions, some of the judgments quoted from the other side, and Your Lordship, in the judgment, I may take 2 minutes to find it, Your Lordship, but I'll try to be as quick as possible. Just a second, Your Lordship, taking in a different way. About the application of Article 121, Your Lordship, paragraph 116 of Your Lordship's judgment.
Yes.
Licensed financial institution, Your Lordship. The definition Your Lordship has quoted there. because this particular bank is not incorporated in the mainland, so this doesn't apply, is what stated. But if you read it, the definition which your lordship quoted, the second and third line from the bottom, either incorporated inside the state or in other jurisdictions. Even
Sorry, at this point, I'm sorry, I haven't, I don't like to interrupt, but none of this is in the grounds of appeal.
Which ground of appeal does this go to, Mr. Shaheen?
Article 121 banking law.
Yeah,
That's
which
not
ground
in the
of
grounds of
appeal?
appeal.
What number of the ground of appeal?
UAE law, application of UAE law.
No, let's go back a step. We'll deal with the UAE exchange case. You have got 6 grounds of appeal. Which ground of appeal does this fall under?
The application of UAE law, your lordship. First
Now,
one.
let me see. That's
You'll find it at page 103, Your Honour, in the
103.
UAE
Thank
exchange
you.
bundle.
So we have argued for application of UAE law, and this particular law, as I explained earlier, it's a federal law, part of the UAE law. It should apply.
But your ground of appeal makes no reference to Article 121, does it?
The broad headline is there, your lordship, UAE law is there. I'm explaining that part, which is also covered in the judgment.
Right. Where in your outline, where in your skeleton argument is this put forward?
I think I did not mention, your lordship.
So it's not in your skeleton argument.
It's not, I don't think I have referred to Article 121, but that's why my learned friend is
And
objecting.
it's not specifically referred to in your grounds of appeal.
Probably that's the reason my learned friend is objecting. I agree with that. But
Yes,
application
so-
of UAE is mentioned, and this is the ground which was discussed elaborately in the judgment. So that is why I pointed.
Which ground of appeal, which number ground of appeal does this fall under?
Ground number one, application of UAE.
Well, no, that can't be right. One is the order has misinterpreted the requirements for the dismissal of the immediate judgment application.
Two, your lordship, sorry for
Pardon?
that. Two. No, sorry. I'll find out. Two. Ground 3, the order is listed with application of Article 8 of the law number 3 of the, this is application of UAE law.
Ground 3, the order has misinterpreted the application of Article 8
And
of
ground 4,
DIFC Law 3 of
and
2004.
ground 4 also read with that. Ground, the order is not confined to
Ground
jurisdiction.
4, the order has erroneously assumed the governing law clause of the NMC disputed personal guarantees. Well, let's deal with that. What's the erroneous assumption about the governing law clause? The court, in the judgment, the court says that the governing law is the law of the Emirates of Dubai and the law of the UAE.
Yes, your lordship, that is where I clarified that. The Honorable Court has rightly applied the UAE law, but certain laws which are not regulatory in character, which are the federal laws which are applicable for consumer protection, have been considered as regulatory, and that's the point I'm bringing here. And Article 121 was elaborately discussed in the judgment.
Well, even if I allow you to take the ground of appeal as elaborated upon in your skeleton argument, your skeleton argument makes no reference to this, does it?
Your lordship is right, and my learned friend is right. My mistake, it is not mentioned in the skeleton argument. But it is UAE law, something discussed in the judgment, and the general principle of a trial is that a question of law can be raised at any time. I don't have to plead.
No, that's not right, Mr. Shaheen. You are bound by the grounds of appeal. You can't just raise anything that you feel like on the hearing.
There is a broad
As
headline.
to the question of law, the point there being, of course, a question sometimes arises whether you may take a point on appeal that was not argued at the hearing. And in determining those matters, the court differentiates between, at times distinguishes between questions of fact and questions of law. That doesn't mean that the court will always permit you to raise on appeal a question of law that was not argued at the hearing. But that's a different point than whether or not your grounds of appeal raise the matter.
It's not only to make a differentiation between raising a new fact or a new law. And law as UAE law application, I have raised it as a ground, Your Lordship. The explanation did not directly refer to one article which I wanted to say, and which I am filling that gap now, if Your Lordship permits me.
Well,
this is
what I'll get you to do, Mr. Shaheen, is in 3 or 4 sentences, tell me what you say was the error in relation to Article 121. And then I'll consider later whether I'll permit that argument to be put. But I want you to tell me just succinctly in a few sentences what you say the error was.
My first point is, Your Lordship, it's not a regulatory provision. It is a mandatory provision under the federal law.
All right.
Offers protection to consumers as the heading denotes consumer protection. That's the first point, Your Lordship.
Okay.
Point is that the definition which Your Lordship has cited in the judgment, 116, paragraph 116 of the judgment, Your Lordship. Financial institutions, the definition, either incorporated inside the state or in other jurisdictions. If they are doing business in the state, this applies. This is the meaning of either incorporated inside the state or in other jurisdictions. So no matter a bank is incorporated in DIFC, if they are doing business in the mainland by lending money here or taking guarantee, this applies to them. And then I clarified already, Your Lordship, the clarification issued by the ministry, who is the most authorized body to say what was the intention of the legislature, was to give it retrospective effect and to apply it to all corporations. This was the
all right.
That's all. So these are the
all
three
right. Those
points.
are the points you wanted to make about Article 121.
And this is how judgment what I slightly disagree with Your Lordship's findings, which I have a duty to put forward. Now coming to
thank you. If you would move on.
390, Your Lordship, current account closure. I mentioned that a current account has to be closed. Only then the borrower
said that.
And then the guarantor's liability kicks in. Now, if we look at it, what my learned friend produced before the Honorable Court, a judgment by the Dubai Cassation Court, Appeal 261 of 2001, paragraph number 152 of the judgment, Your Lordship.
Sorry, the paragraph 152 of the judgment?
Yes, Your Lordship.
Okay, just bear with me whilst I get that. Yes, I have 152.
Yes, Your Lordship. Ms. Sullivan referred to judgments to the Dubai Court of Cassation, which reject the argument that a personal guarantee is invalid unless it states a specific figure. In Appeal 261 of 2001, writes the Court of Cassation said, this is how the thing reads. Then within quotes, the relevant portion of the judgment is quoted. It is established by legal precedents of this court that the guarantee of future debt is invalid. First thing, future debt. There are several references to future debt in the definition of indebtedness, in the definition of financial documents, in the definition of other terms which were defined, which I elaborately took Your Lordship to, except where the value of the guaranteed debt is defined in advance in the deed of guarantee. Now, the next sentence is the most important thing, Your Lordship. About the application of Article 390, why closure of current account is most important there. It is established also that the guarantee of liabilities arising from a current account, any finance facility go through a current account. Opening contract is a future debt guarantee, the amount of which shall be capable of calculation only when the account is closed, only when the account is closed, unambiguous language, and finally liquidated, and the balance in respect thereof is settled and drawn up. It is also determined that the guarantor's liability shall be limited to the amount of the guarantee. So it's not enough in the Only when the current account is closed is definitely stated where the liability comes in. Only when the borrower is liable, I'm liable. So being void or other aspects are different. But what am I guaranteeing? I'm guaranteeing the borrower's liability, which I explained. And borrower's liability to be due for payment is the language of the guarantee. And the Supreme Court has clarified here that only when the current account is closed. It doesn't stop there, Your Lordship. Paragraph 155. Paragraph 155 of the judgment. In Appeal 79 of 2008 commercial, the Court of Cassation said, a guarantee is not valid except if its parties identify precisely value of the guaranteed debt in the guaranteed agreement, or if the guarantee agreement contains the basis upon which the guaranteed debt may be calculated. It contains a clause how it calculates, but the facility agreement stretches it beyond imagination. At a later date or identifies the nature of the facilities being granted. All the nature of facilities granted are not identified in the guarantee. Even the facility agreement, the definitions go too wide. Now, the next clause is what I am underlining here, Your Lordship. It is also decided that the guarantee of obligations arising from a current account is a guarantee of a future debt, which cannot be ascertained precisely until such time as the account is closed and accounts in respect thereof drawn up. So, it is the duty of the financial institution, the bank, to prove that this current account has been closed and this is exactly the amount which is due and this is your liability, the guarantor. You have to pay now, which I had raised this contention before Your Lordship during the trial and in my skeleton arguments both places, and that has not been addressed by the bank. And again, God is great. I'm getting the judgments and references from
But Mr. Shaheen, my recollection is that the bank terminated the facility and calculated the amount that was owing under the facility.
The Honorable Supreme Court is saying that's not the way. Only the account at the closure of the current account. Wherever the current account is not closed and a case is filed before the Supreme Court, either in Dubai or Abu Dhabi, the case has been dismissed.
Well, whether you say the account is closed or terminated is the same thing, isn't it?
Not, Your Lordship. Closure of the current account is different from a letter saying that terminating the facility. It's still, they have stated in their submission, they have stated every day 5,000 dirhams, $5,000 is accumulated. If a current account is closed, full stop, nothing will accumulate afterwards. That's the final.
It's not a current account, it's a term loan. Just to say, it's not a current account.
Sorry, my friend, it's not
Point
a
is
term.
completely misguided. It's not a current account. A fixed sum was lent and guaranteed.
It's a facility agreement, and the definition of financial indebtedness goes beyond term loan or financial liability or whatever. Anything, even a term loan, to be granted has to be a current account. Other than a current account, nothing will carry a debit entry. So this judgments quoted by the claimant really helps me in application of this Article 319, the Commercial Transaction Law. The debt is not due for payment. There is no case that the current account has been closed.
But this was not the guarantee of a current account.
Guarantee of a facility agreement, okay? And the facility cannot go other than through a current account. So if the amount has to become due, the current account has to be closed. Otherwise, debit and credit entries will cancel each other.
All right.
The definition given the current account is a contract between two persons whereby the rights and debts arising from their mutual relation turn into entries in the account to be set off between each other, so that the final balance alone upon closing the account shall be due debt, shall be a due debt. Article 391, the bank may open a current account to its customer if the operations conducted by the bank for the customer is coupled with opening a credit or credit facility in favor thereof. A loan is also a credit facility. You're giving something, you need to collect it back. Agreement may be made that the current account is not overdrawn by the customer, so the balance always remains payable, minimum balance requirement. It may also be agreed that the account is overdrawn of both sides, so that the balance is payable or receivable for both parties. This is the definition given to the current account, and the requirement is only at the closing of account, which is reconfirmed by the two judgments produced by the claimant.
All right.
So I've covered all the grounds, Your Lordship. Now I'll just look into the judgment. If I have missed something, if Your Lordship can bear with me for 10 minutes maximum. The schedule of reasons, paragraph number 13 is the one which referring to the claim against UA exchange is subject to a standstill agreement. I haven't got sight of it, Your Lordship. I don't know what are the terms and conditions of that. So that standstill agreement may say that this amount is not due for payment until such date. Then I should not be sued. Only when the amount is due for payment, I should be sued. That's one regarding the standstill agreement. And paragraph number 8, as Your Lordship rightly quoted, it may not be appropriate to decide difficult questions of law on an interlocutory application where the facts may determine how those legal issues will present themselves for determination. And the legal issues are in an area that requires detailed argument and mature consideration. Definitely this case, Your Lordship. All that what we discussed today, it requires a mature consideration, Your Lordship. We are not supposed to conduct a mini trial. If we go into this, we are conducting a mega trial. Only thing short of is cross-examination of witnesses. That should not happen. This is Your Lordship's wording in paragraph number 8, Your Lordship. And the overall burden of proof remains on the claimant. That's always the case. There will be a compelling reason for trial where there are circumstances that ought to be investigated. There are things to be investigated. The last page is attached to the personal guarantee. It needs to be investigated. The veracity of the testimony given by the bank.
I think you've made that submission already, Mr. Shaheen.
I'll not repeat now. We'll go fast. Several places, again, Your Lordship, like paragraph number 43, Your Lordship has stated that they have produced that accounts maintained by the claimant as prima facie evidence, and there is no evidence to contradict the account. There is no one here to contradict that account. Is the sorry, pathetic situation, Your Lordship. I cannot. I have no access. I'm not privy to those documents. The borrowers are not in the picture. So it's not correct or prudent on our part to expect somebody will contradict it when the goalpost is empty. And here 47, Your Lordship is saying neither NMC Healthcare nor Mr. Shetty nor any other defendant has paid any sum in response to this demand. How do we know? Other than the bank's own self-serving statement. Mr. Shetty has not paid because I can say that because I'm acting on his behalf. Others, whether they have paid or not, we have not checked with them. And no expert report also here. This is paragraph number 60 and 61. This is where I mentioned. He starts at 14:20 and reaches the office in 61 at 3:50, exactly 1 hour 30 minutes. If you ask what is the time between Dubai and Abu Dhabi, I'll say 1 hour 30 minutes, provided you're sitting in the car at the first minute, not signing the register up in the bank's office. So these are all elements by which I can definitely challenge his memory, his way of stating things, overstating things. I can do that. But I must be given an opportunity to cross-examine him, not otherwise. So that's a necessity for a trial. 65, Your Lordship is asking the question, what then is the evidence to contradict the evidence of Mr. Srinivasan, supported by the documents I have referred to, and the circumstances surrounding the negotiation for and drawdown? This is again a matter for cross-examination, why a trial is required. I need to go for an investigation here. Mr. Shetty has made no witness statement, Your Lordship has stated, but his statement of defense he has signed the NMC case, and which is verified statement. So it is under oath that he has stated. In the other case of Bank of Baroda, Lord Justice Glennie has confirmed that that can be used as equal as the witness statement, something under oath he's stating. So he's relied on that.
Sorry, what may be used?
A verified statement. So when the defense statement is signed by Dr. Shetty, and there is a verification.
But he hasn't made, I don't think Mr. Shetty didn't verify his defense statement, did he?
He did. He did in NMC case. In NMC case, one case he did not. And even Mr. Benai, while setting aside the default judgment in the case against UA Exchange, he had done a witness statement denying the signature. That's also before the Honorable Court. that article which I quoted, that bank shall have sufficient securities, it is 409 subclause 2, Your Lordship. I think by mistake I said 490. It's 409 subclause 2 of the Commercial Transaction Law, which obliges the bank shall have sufficient securities or guarantees against the provided. Your Lordship was asking what is the consequence? Consequence is 121. I'm referring to 121 of the banking law. And the NMC guarantee wording, Your Lordship, 145. Any or all sums of money that the borrowers are obligated to pay to the bank under the facility agreement. So what is obligated, the borrower is obligated to pay to the bank has not been determined is the argument. In paragraph 174, Your Lordship has stated the claimant does not have to prove that the borrower is in fact liable to it under the facility. There I beg to differ with Your Lordship, because it is the liability of the borrower which the guarantor is guaranteeing to pay. So that liability has to be determined. Because the previous 173, the quote between the last line, in respect of its obligations hereunder. So indemnity is in respect of its obligations hereunder, and the obligation under the guarantee is to pay what is due from the borrower to the bank under the facility. So that need to be established is my humble submission. Again, with UAE exchange case also, Your Lordship, 211, paragraph 211, Your Lordship is saying that about the statement which the bank produced, the defendants adduced no evidence to contradict the account statement. I have no means to adduce any evidence, Your Lordship. I'm a third party. I'm not privy to the document. I have said it a few times. I don't want to repeat, but it's not prudent on our part to have.
I think you're really repeating things you've already made submissions about now, Mr. Shaheen.
Just a few minutes, Your Lordship. I've reached page number 43, right. Only just more.
All right.
And whenever it is stated amount due is 35,150,000, it's all one party statement. It is stated in the immediate judgment that the Honorable Court should not follow what one party is saying in the immediate judgment application. It is stated there. Deed of standstill, I already mentioned, Your Lordship. We don't know the terms of the standstill agreement. And the two witnesses verbatim stating something about the presence of the people, I have already made mention about it. Mini trial also I mentioned. And now about the application that we have submitted for expert appointment, Your Lordship. Can I submit on that?
So you want to deal now with your application for permission to appoint an expert?
In the UAE exchange case, Your Lordship.
Yes. Why do you need permission to do this? Well, perhaps there's any number of questions I could ask you. Perhaps I should start at the other end. The bank says what appears on the face of it to be a sensible proposition that it's all too late. There's immediate judgment against you. For what purpose are you going to appoint an expert?
The reason is why. First, I have to say why I could not do it earlier in the exchange case. Why
you could have done it earlier.
That is what I'm trying to explain. Why I could not do it.
All right.
If you're, first of all, the counsel for the claimant, by way of an email dated 14 September 2023, made a request in the hearing of the immediate judgment.
Where is this in the evidence?
Pardon me, sir?
Where is this in the evidence?
No, I'm saying there is an email which was presented by the counsel.
Yes. So you're saying you're trying to go to some evidence. I'm asking you, where is the evidence in the case bundle? If it's not in evidence before me, I can't have regard to it.
This is something, an email submitted to the court, Your Lordship, to the registry.
Well,
to the DIC.
But you've got to put it in evidence if you want to rely upon it. You can't just start telling me about things that are not in evidence.
Now, all I'm saying is, Your Lordship, is now I'm not going into the nitty-gritty what is stated in that one. I'm only saying that it was only on 14 September 2023, an application was submitted for the, we say consolidated, but they say joint hearing. And what is written in the judgment is consolidated hearing. It's a hearing is consolidated. Cases are not consolidated. Right? Now, they stated both cases, the immediate judgment application has been filed. One is 13th July, and we had submitted an application 9th August for stay of dismissal or stay of all proceedings. They submitted application for immediate judgment on 13th July, whereas 9th August, we submitted application for stay of all proceedings or dismissal of all proceedings. The other case, UA exchange case, it was on 13th September, the application was submitted. Because the ground is that both are similar nature and involve same parties except one additional person in UA exchange. So they said in persons of the overriding objective, it's in the interest of everybody, this should be combined. And then the registry.
I'm sorry to take you back, Mr. Shaheen, but I'm confused. Why are you seeking permission to appoint an expert in a case where judgment has already been given against you?
We are trying to reopen that by seeking a permission to appeal, and also going on appeal is
Well, wait a minute, you're trying to reopen what?
The judgment which is already issued could be challenged in an appeal, and I'm seeking your lordship's
Well,
permission.
you've made your application for permission to appeal, and we don't know yet. I'm going to reserve my decision. If I grant permission to appeal some or all of the grounds, then it would go on appeal. And if the appeal is successful, then there would be no immediate judgment, and perhaps then you might apply to appoint an expert. But at the moment, there's a judgment against you. The case is finished. Well, why would you be? What's the purpose of appointing an expert?
While challenging the judgment in appeal, whatever I could do, I'm doing it, your lordship, because his lordship, Chief Justice, said that you should ask for appointment of this is the least that least is.
Well, you
just
should have
denied.
done that. I think what the Chief Justice was saying was that in resisting the application for immediate judgment, you must bring forward such evidence as you rely upon to resist the application. And
Yes.
the Chief Justice was indicating that that may well be, and probably should be, if you seek to rely upon it, expert evidence. But
That's
you've
why
had that opportunity and the day is gone.
the two stay applications were pending, your lordship. Two stay applications were pending. Application for dismissal, application for stay was pending. That was not adjudicated. Still, in one case, by abundant caution, we did apply for an expert that was allowed, an expert report was before the Honorable Court. The other case, we could not do it. The other case was posted for a case management conference, which got vacated all of a sudden. And then it went into a joint hearing. So that's where we lost that opportunity. We could not do it in the other case.
Well, why couldn't you? You did appoint one expert. You appointed Mr. Elbar. You
Yes,
appointed
yes.
him. There's nothing to stop you doing that, and you did it. You could have done it in the other case as well.
That case started almost 1 year before this one, your lordship. The case management conference was done. The application for expert was mentioned there. There was a timeline fixed for everything. We followed that timeline. We were hoping the same thing will happen in the other case also. But then the case management conference got vacated, and suddenly it's all going for immediate judgment. So we lost that gap in that. There was a time lapse. So that is how we lost that opportunity, and we are bringing it back now.
All right.
So, and the submission is that from the other side, there has been no attempt to prove the liability, no expert, no attempt to prove the signature. The burden of proof is heavily on the claimant, on the person seeking immediate judgment. I did not ask for an immediate judgment dismissing the whole case. If that was the case, entire burden would have been on me. I would have had to do all this conclusively prove that the signature is forced, which is not required in this case. I just also real prospect. Possibility is also word used by the Chief Justice there in that Madhrui case. So the burden is on the other side. Since they are not doing it, I am actually asking for that opportunity, which I lost because of the manner in which the case management conference got vacated and it suddenly went into a joint or consolidated hearing where the cases were decided. So I had lost that opportunity in that case. That's a submission. One, just a general doubt, Your Lordship. In the judgment in one place, Your Lordship had stated, the courts of Dubai includes the court of the IFC also.
Well,
It doesn't
that's
affect
to
my
do with jurisdiction. There's no appeal against a finding that the court has jurisdiction to hear these matters.
So by that logic, wouldn't UAE court also include the IFC court?
I'm sorry, what did you say?
The courts of UAE will also include the IFC court. I'm just thinking about the chaotic situations it can create in future for other agreements where it is UAE courts and DIFC, ADGM, everybody can look into it. It doesn't affect.
I don't have to concern myself with that today because, as I've said, there is no appeal on the grounds that the court does not have jurisdiction.
Nothing to do with my grounds of appeal, Your Lordship. Just a doubt got in the mind when I was reading the judgment. First time seeing that, so I raised it. So that's for today, Your Lordship, and my humble submission. Your Lordship, please grant me the permission to appeal so that I have a chance to ventilate all the grievances.
All right. Well, thank you, Mr.
One more point, Your Lordship. There was a supplemental skeleton bundle submitted by the Claimants Council. It was delayed by 1 day. The date fixed was 25th and the submission was on 26th. So we have opposed that, the skeleton bundle. I'm just mentioning what has happened in the procedure.
All right.
So thank you much for the
patience.
Much obliged.
Thank you for your assistance. What I propose to take now is a short break before I invite Ms. O'Sullivan to make her submissions. We'll make it about 15 minutes or resume at, I think that would be, say, 12:20 Dubai time, if I'm got my clock right. So we'll now adjourn until 12:20 Dubai time.
Thank you.
Thank you. Yes, I can see both of you. Are you able to hear me?
We can hear you, Your Honour, yes.
All right, thank you. I'm having a little difficulty today, so I need to check. All right.
It happens to all of us.
Thank you, Ms. O'Sullivan. It's your turn.
Your Honour, I shall be much more brief than Mr. Shaheen. You have approached these two applications, the application for an extension of time and for permission on a rolled-up basis. And I shall just address them in turn. We obviously invite you to reject the application for an extension of time and therefore dismiss the application for permission on that basis. Now, as we've submitted in our supplemental skeleton, the DIFC courts take a very strict approach to compliance with the rules for seeking permission to appeal. And the reason for that is the respondent is entitled to know with certainty whether the judgment is final or whether it's going to be appealed. And for my learned friend to take the approach that, well, it hasn't caused any prejudice, that's completely not the approach. In fact, the authorities indicate that the appropriate approach is for the respondent to the applicant to make an application for relief from sanctions. And that, as your lordship will be familiar with, the threefold test. Firstly, you ask whether the breach was serious, which in this case it clearly was. Secondly, you ask whether good reason has been given for the breach. And thirdly, you consider what the appropriate order is, taking into account all the circumstances of the case. Now, there's been no application for relief from sanctions. There's absolutely no consciousness on the other side of the importance of compliance with deadlines, or many other rules for that matter. The explanation given is entirely unsatisfactory. We still aren't told what the technical reasons are. It seems that the appellants themselves, rather than the lawyers, were making the payment of the fee, which is, in my submission, an unusual approach. Normally, it would be the lawyers that would do it, and there's no explanation as to why that course was not taken. They seem to have encountered problems which are not said to be the responsibility of the registry, it's at their own end. But this is the thing, this is why you don't leave it until the very last day in case there are issues. They left it till the very last possible day and then they had issues. And even then, it seems they didn't say to their lawyers, you better make the payment, we're having difficulty. And that wasn't done for another few days. And then it seems there was the further mistake, which we haven't heard any evidence about until this morning, which is that the appellant solicitors obviously didn't realise that they needed to make an appeal in both the cases. So again, incompetence is not a good reason for extending time. And the appeal notice in the NMC healthcare case wasn't even filed until the 2nd of May. So essentially, we say that the applying the threefold test, the breach is serious. There's no good reason for it. It seems to be the fault of both the appellants and their lawyers, and that you should refuse this because you'll be thereby underscoring the importance of strict compliance with the rules and showing they're not simply something that as a litigant can ignore at its election, but they are serious. As Justice Madani has explained in the Mad Atelier case, which I referred to in my skeleton, and that's because it's a huge waste of the resources of the court, apart from anything else. People don't comply with the rules. Anyway, but that's all I have to say on the application for an extension of time. Now, coming to the substance, and obviously what my learned friend has done is try and treat this as a rehearing. He hasn't addressed the permission for it to appeal test, which is that he has to show a real prospect, not of success in the original application, but a real prospect of showing that your lordship's judgment is wrong in some respect, or that there's some other compelling reason for trial. He hasn't even addressed those grounds. And in my submission, the test is not met in respect of any of the proposed grounds of appeal. And his submissions stray massively outside the grounds of appeal. And I'm going to make my submissions. I mean, firstly, I would invite your lordship to have regard to my written skeleton. I'm not going to repeat what I said there unless your lordship wishes me to go into anything more detail. But you have my submissions on those points. And that, for reference, is at page 106 of the NMC healthcare bundle. I'm afraid I don't know where it is in the other bundle. But what I'd like to do is just look at the grounds of appeal. For example, in the UAE exchange case, which one finds in the UAE exchange bundle at page 103, to see what the actual grounds of appeal were.
Yes, I have it.
Yes, so the first ground is so the order, that means the judgment has misinterpreted the requirements for the dismissal of the immediate judgment application in the case of a claim of forgery, mistake of law. Now, that it's not a mistake of law. I mean, there's no suggestion that your lordship has applied the wrong guidelines. I mean, the Al-Mazraoui guideline, your lordship has, in fact, in my submission, correctly applied those guidelines, and there's no mistake of law. The complaint here is that they don't like the outcome. But your lordship has not fallen into any error, as you rightly explained in the judgment. There is at least an evidential burden on someone saying that their signature has been forged to produce some supports to bear out that allegation. All you've heard today and previously is speculation, and wholly improper speculation. Now, my clients are going to have to give serious consideration whether to refer Mr. Shaheen to the DIFC on the basis of these wholly unsubstantiated and improper allegations of fraud. This is a professional conduct matter. Lawyers should not devise allegations of fraud without instructions and without any proper basis for them. And we're going to ask your lordship to mark disapproval of that approach in your reasons, because you need to take a stand against lawyers who come to this court and spray around allegations of fraud and dishonesty, which are utterly disgraceful and should not have been made. I mean, it's quite clear that Mr. Shaheen was alleging dishonesty by the bank and dishonesty by its witnesses. He said there was several times there was a cover-up and that the bank's evidence was self-serving. What he means is it was untrue and false. And that is an absolutely disgraceful thing to say without a shred of evidence or even his client's instructions. As your lordship rightly observed in the judgment, his client's case is not that the bank has done anything wrong, but that someone in his own office may have attached his signature or may have forged his signature. So that is a purely lawyer-invented allegation, which is utterly improper. So the second ground of appeal, it says the order has not considered the grounds raised in the UA exchange case. I mean, again, I addressed this briefly in my submissions. I mean, this again seems to be an allegation that they don't like the outcome. I mean, of course, your lordship did consider the grounds. You just didn't agree with the the arguments. And I mean, they don't. I mean, that's completely unparticularized what they say the mistake of fact and law is. But essentially, it seems to be that the complaint is that your lordship preferred the written evidence of the bank against the absence of evidence on the part of Mr. Shetty, which of course your lordship was right to do and fully entitled to do. And there's literally no prospect that the Court of Appeal will interfere with your lordship's decision on that point. The third and fourth grounds, now, being very charitable to my learned friend, what they seem to be saying is that your lordship ought to have found that federal laws applied to both guarantees, even though the UAE exchange guarantee is governed by Difc law. Now, again, no, I mean, that doesn't appear at all, but and I've addressed why that's wrong in my skeleton. I mean, we didn't, because they haven't identified which federal laws they say you ought to have applied, we took a guess in our skeleton and we said, well, that might be a reference to 1061 of the Civil Code. We were puzzled because obviously your lordship did apply that article. But I think what Mr. Shaheen is now saying is that you should have applied 121 bis of the banking law. The federal banking law. Now, I mean, the issue here essentially is does a federal banking law apply to a DIFC party? And for the reasons which you gave in your judgment, which I have to say have not been challenged in any ground of appeal or in the skeleton, were obviously right. As I've said in my skeleton, you gave multiple grounds for saying Article 121 of the banking law simply doesn't apply. Firstly, the claimant isn't a banking, doesn't carry on in what you might call onshore Dubai. It's a DIFC registered institution. It doesn't do any business in Dubai. It's regulated under the regulatory law by the DFSA and not by the central bank, as it would be if it were an onshore bank. And there are different regulatory regimes, and that's part of the whole structure of establishing free zones. The free zones have their own regulator and their own regulatory regimes. And your lordship quite rightly found it would be contrary to public policy if a DIFC institution could simply opt into a different regime. But that point has not been understood or appealed by the other side. You also, I mean, so you made the point that this is not, the claimant is not is established in the DIFC, and it's not a licensed financial institution to which the banking law applies. And you also made a point that on the construction of Article 121, guarantees doesn't apply to guarantees of lending to a corporation or retrospectively. Now, and on those points, you were supported by Dubai law on that point. I mean, we cited a Court of Appeal, a Court of Cassation case, which said, firstly, that it doesn't apply to corporate lending, and secondly, that it would be contrary to the UAE Constitution to apply it retrospectively. And so it's something for my learned friend to submit that your lordship has misapplied the law, and it's confirmed at the highest level of the onshore courts. And you also went on to consider this. I think is possibly the article that Mr. Shaheen may have been groping towards, the idea that if the parties have agreed UAE law, then that means that they have opted into the full range of federal laws. I mean, that is really problematic because, as you know, the waterfall provisions in the DIFC provide that regulatory content takes priority over the party's choice of law. And your lordship has rightly found that there is regulatory content in that the provision of financial services in the DIFC is subject to DIFC law and the DIFC regulation, and not federal law and federal regulation. As I've said, there are two separate regimes. So, even imputing a coherency to my learned friend's argument, which it lacks, your lordship clearly got that point right. It's an important point, but your lordship's judgment is, with respect, very thoroughly and fairly reasoned, and there's simply no basis for suggesting that the Court of Appeal would think otherwise. And the same really goes to Article 106.1 of the Civil Code, which, as you recall, we initially took the position that had been waived, and then we decided that was wrong. So we accepted it applied. And so there's no point of law here. I mean, it's simply a question of construction of the particular guarantee. I mean, you differed from Justice Lord Glennie in the velocity industry cases, because, I mean, it's very different wording, and he was dealing with an all-money guarantee relating to complete other potential lending and all sorts of other agreements, very, very widely worded. That is, I understand, going on appeal. Mr. Shaheen would be better informed about this, and I don't think my research suggests the case hasn't been heard, but that case is going to be heard by the Court of Appeal anyway, so it's undesirable for you to reconsider the point on different wording. Better to hear what the Court of Appeal say on the application of 106.1. But in any event, I mean, it's quite clear in my respectful submission that you did get the interpretation right.
So, Solomon, do you mean
Well,
I should wait to deliver the decision until the Court of Appeal has? No,
I would say you shouldn't. No, not at all. Actually, it would be undesirable for you to give a conflicting permission. I mean, the Court of Appeal is already going to consider all these matters.
I see.
But I mean, I said, I mean, the reason why I say you shouldn't give permission is there's simply no error in your construction. This is not an all monies guarantee, and it is not a guarantee of a current account. Current account. The point about a current account is the amount due will fluctuate from time to time, but this isn't that kind of arrangement at all. It's a term loan for 50 million made up front, repayable in instalments with interest, and there's no lack of certainty about the amount for which the guarantor is on the hook. And that it falls absolutely within a number of Court of Cassation decisions of the Dubai Court of Cassation, which say essentially, as your lordship recognised in the judgment, that's good enough for Article 106.1. And then, so that's ground 5. And then ground 6, they say quite wrongly that you didn't consider the implications of 391 and 392 of the Commercial Transactions Law. That's quite wrong, because obviously you did. You found that it didn't apply because, like the federal banking law, it's an onshore law. As we know, these onshore federal and commercial laws do not apply in the DIFC, and which is a point that they have not taken issue with. I mean, I find it very difficult to understand. I think the argument was that the account needs to be closed so that the liability of the principal debtor can be ascertained, and only then the guarantor is liable. Well, I mean, leaving aside whether that's right in law, that's obviously what has happened. I mean, as your lordship saw, there was a statement of account. At one point, the bank classified the loan as a non-performing asset, and they closed it and moved it over to a different account with the bank. You saw all this evidence. And there's a statement of account showing with precision to the last cent the incoming and outgoing, the interest payments, the payments made, the payments outstanding, the penalty interest applied, and it is Mr. said he can't challenge it, can't, because there's no basis for supposing there's anything wrong with it. The liability has been quantified and established. And so, I mean, really, unless there's anything I mean, I'll come to the application for expert evidence, but I mean, you addressed the points. It's far too late. They had plenty of time to do this. The Bank of Baroda case, on different facts, essentially what happened is Justice Martin found in that case that the bank had limited Mr. Albar's time for inspection. Therefore, he felt he ought to give Mr. Albar the benefit of the doubt, that with a bit more time, he might have done a better report. And I think it's fair to say he was pretty sceptical about the report. But he thought he ought to give Mr. Albar that's obviously a judge making a case management decision in a different case.
Solomon, I should have asked Mr. Shaheen this. I've not found that case because the citation leaves out the date of it, I think. You've obviously found the case.
Well, I mean, I think it was March. I mean, I think it was decided in March, and essentially, this was another of these cases, exactly the same defence. Justice Martin gave judgment against the principal debtor, which actually unusually was not one of the companies in administration in Abu Dhabi. But he said that he would give permission to defend on the sole issue whether the signature on the guarantee is genuine, because he felt that although Mr. Albar's report wasn't very satisfactory, he might have been able to do a better job if the bank had allowed him to come back for a second day. So there we are. So that's now proceeding to trial on that one issue. And we have a case management conference next month. And Mr. Shaheen and I are obviously on opposite sides of that case, so we know all about it. But I mean, you don't need to know any more than that. It is reported, but it's obviously specific to its own facts.
Right.
I mean, you know, there's certainly no finding by Justice Martin that there's positive reason to suppose that the signature is not genuine. He's simply that, well, Mr. Albar ought to have been given another opportunity to do a better report, in a nutshell. I mean, that in a nutshell is it. I mean, we would invite you to refuse permission on all grounds, but as you've seen from our skeleton, if you were minded to grant permission on any, we say it should be conditional on payment of the full judgment sum into court. I mean, that seems to pass my learned friend by. There's been absolutely nothing said about the security application, but obviously I submit that you should impose the conditions that we've asked for in our skeleton.
Yes. All right.
Thank you very much, my lord.
Thank you. Mr. Shaheen, both in reply and in response to the question about conditions, in whatever order you want to.
Yes, Your Lordship. I just read one paragraph from the judgment in Bank of Baroda case, Your Lordship. In that case, there was an expert appointed from the bank side also.
You're talking about the Bank of Baroda case?
Bank of Baroda case, which is...
Can you give me the date it was decided?
The date was 11th March 2024.
11th of March. All right, thank you.
Subsequently. So this was a case where, so I'll just read those two paragraphs and then I can explain the Lordship. 201, paragraph number 201 in the judgment. The question posed by the criticism of Mr. Albar's report presented by senior counsel for the bankers, whether I should resolve the claim against Dr. Shetty by determining the issues with respect to the forgery of his signature on the personal guarantee on the papers by comparing the expert evidence adduced on behalf of the bank with the expert evidence adduced on behalf of Dr. Shetty without hearing from either expert. This is the question. I have concluded that proceeding in this way would, in effect, be to conduct a mini trial contrary to the principles established by the authorities which I have referred. In the particular circumstances of this case, the possibility that Dr. Shetty might establish that a signature on the personal guarantee was forged cannot be entirely excluded at this stage of the proceedings. Unlike the forgery issues raised on behalf of Neopharma, if it were established that Dr. Shetty did not sign the personal guarantee, that would arguably be a complete defense to the bank's claim against him. Of course, I take into account of the fact that Dr. Shetty has not provided a witness statement denying execution of the personal guarantee. However, he did apparently sign a statement of truth in relation to the defense in which that assertion is made. So there must be some prospect that such a witness statement would be provided if the matter goes to trial. I have therefore concluded that there is a real prospect that Dr. Shetty might be able to establish a defense to the bank's claim, and that prospect should be determined by a trial. So this is precisely what exactly happened in that case, Your Lordship. So in that case, at least that bank had taken one step by appointing an expert attempting to prove the signature of Dr. Shetty. Whereas in this case, we don't even have that. We have only one expert report. And whatever we call it speculation, it actually cuts the root of a conclusive proof. When there is a speculation possible, is my humble submission. And I've elaborately discussed on that, why loose pages cannot be considered, all that. So this portion of the judgment is of relevance, Your Lordship. This is the judgment in CF 5 043 of 2020 Bank of Baroda case, Your Lordship.
Yes. All right.
Thank you. I might simply add that another point of difference between this case and the Bank of Baroda is that Bank of Baroda weren't able to produce a witness who'd seen Dr. Shetty sign the guarantees. So, you know, that's a point of difference.
Yes.
Whereas here we've got, I think, 4 witnesses on different occasions who saw the Shettys sign the guarantees.
Madam Sullivan, if you may allow me.
Please continue, Mr. Shaheen.
Yes, Your Lordship. Actually, they had also produced witnesses for the signatory part. And the finding of the expert was appointed panel mostly has been signed by Dr. Shetty. And the assertion that the signature on the document does not appear to be genuine and raises suspicion concerns. It may be forged or pasted electronically on this document. These were the findings of the expert. It's more in favor of the bank than what we are seeing in this case, Your Lordship, because only 1 page. Witnesses were there in that case also, evidencing the signature part, everything. But this is the finding of His Lordship, saying that if I go to examine the expert reports, I'll be conducting a mini trial, which is against the principles of granting an immediate judgment. Therefore, I say there is a scope for a trial, and they stopped at that. This is what happened, which squarely applies in our case also, Your Lordship.
All right. What other matters did you want to put in reply, if any?
If there is any clarification required, I'm ready, because Your Lordship said I was repeating.
What about the bank says that if I grant permission to appeal, it should be on the conditions set out in their submissions. What do you say about that?
Procedurally correct, and my humble submission, I was talking about application of UAE law, and Your Lordship has already said it is applicable. The differentiation I'm trying to bring there is that it's not regulatory. The banking law is not regulatory. It's not issued by the central bank. It applies to all the financial institutions who are doing business in the territory. It states no matter whether they are registered in the state or outside in any other jurisdiction. I quoted that portion also from the judgment. It applies not even if the bank is not registered in UAE at all. Suppose somebody coming from Singapore, if they lend money in UAE, if they do business in UAE, then the law applies because it's a federal law. And it's in Abu Dhabi, and the ministry has clarified. The borrower is in Abu Dhabi, the guarantors are in Abu Dhabi, and the ministry has clarified that it has got retrospective effect, and it doesn't get hit by Article 112 of the Constitution because it has got retrospective effect as clarified by the legislature itself. Plus, it applies to corporations also. So the protection that the guarantor was expecting is lost. This is the submission. Retrospective effect is granted. So it applies to all financial institutions anywhere in the world if they are doing business in UAE. And even if we go by the Dubai court judgment saying that it doesn't apply in Dubai, it's by the ministry in Abu Dhabi, still we are in Abu Dhabi. I don't have to argue on that, Your Lordship, because the borrower and the guarantors are in Abu Dhabi. Conflicting judgments are there, but this is not a place of binding precedents, whereas the clarification by the legislature itself, which clarifies the intention of the legislature, which is the paramount consideration in interpretation of statutes, comes in our favor.
All right.
390 also falls under the same way, Your Lordship. I specifically pleaded also. It's not a pleading, it's in the skeleton arguments, but it all comes under the application of UAE law. The opt-in clause, Your Lordship has rightly put it in the judgment. By opt-in clause, we are bound to follow UAE law in NMC case. And only thing is that when Your Lordship analyzed the provision, Your Lordship put it as a regulatory one. That is where I beg to differ, because it's not a regulation issued by the central bank, it's by the federal government. Everybody has to follow. It comes under the heading consumer protection. Yeah, 1061, I already elaborated, and I took Your Lordship to the definitions given in the facility agreement, because that is how the definition in the personal guarantee is. Personal guarantee refers to the finance agreement, and finance agreement has got this wide definition, which could even be bigger than the all monies guarantee. It goes so many places from there. So that is why the serious questions of law, dispute debates on serious questions of law are also matters for trial. We shouldn't be conducting a mini trial. So it should go for trial, fit case to go for trial. An expert witness produced by only one party. At least in the other case, Bank of Baroda case, both parties had submitted expert report. Despite that, the Honorable Judge decided it has to go to trial. We cannot examine the veracity of an expert witness. We cannot examine the veracity of a bank's employee. I could even say interested witnesses also. We cannot examine the veracity of those statements. I just highlighted one or two small things in that, how they are verbatim copying each other. So it is a case fit for trial by all means, Your Lordship, and we should not be conducting a mega trial. It's not even a mini trial what is required at this stage. So many questions of law. The current account, I agree that it is a term loan. I agree that there is a facility agreement, but any facility, Your Lordship, any negative entry, any debit entry possible only in a current account. You cannot give it through a savings account. You cannot give loan to a term deposit account or a fixed deposit account. It requires a current account. Once the amount enters into the current account, the principle is that the explanation given by the courts is that it loses its characteristics. It is just a debit entry or a credit entry. And that settles, the set off happens automatically between the debit and credit entries. Only the final amount is the amount due for payment. That statement, this has to be closed. And there's no evidence that the current account is, I'm citing from the judgments produced by the opposite side, how that is looked into by the local courts. And the opt-in clause is there. The law of UAE has to be applied to the NMC guarantee. We have no choice. It is clearly stated there. And the judgments produced from the other side, I'm not even producing that. It is clearly stated only at the closing of the account. Closing of the account alone. This is the strict language used there. I've cited it from the judgment, Your Lordship. So closing of a current account. So these are all very serious questions of law. Only decided in a trial. Even checking whether the expert is right or wrong in saying something, Honorable Judge said, I will not do a mini trial. Even checking that is a mini trial according to him. And he said it has to go to trial. Here, our case goes much beyond a lot of other issues here. Many questions of law under UAE law. And the prudential rules also, Your Lordship. Though it is, when we say that it is a DIFC entity, it is DIFC law in UAE exchange case. I cannot completely argue with that much force that it is UAE law to be applied to the UAE exchange guarantee also. Only thing is it is a consolidated hearing, so we refer to each other. That's all I can say. Nothing more than that. The entity is, the lender is in DIFC and the governing law is DIFC law. That is why I said about the prudential rules, the regulatory provisions, they should have complied with. 6 months after the Muddy Waters report, completely the reputation is tarnished, the whole empire had collapsed, enhancing the facility and granting another $35 million. This is absolutely irresponsible. This is not what anybody dealing with a reputed bank institution would have ever expected, especially the prudential rules, the precautions, what they should have taken periodically in ensuring that the classification remains good, is not declassified. They are not losing the credibility. The credit bureau reports are easily available. There is authorization to the bank to take it. Nothing was done. It was done in a very haphazard manner, irresponsibly granted, and the guarantor has been taken for a ride. Again, this prudential rules, how it applies, how it protects, when it violates, how it hurts. All these are serious questions of law to be determined in it. I did not submit an application for immediate judgment. Burden of proof is not on me. I'm pointing out factors why this case has got serious contentions which should go for trial.
All right.
That's all.
All right. Thank you. Now, the Ms. Sullivan submitted that if I give permission to appeal on any of the grounds that you rely upon, then the court should impose conditions upon the grant of permission, being the permission set out in the supplementary outline, which includes that you should pay the judgment sum into court. What do you say about those submissions?
I oppose that request and say in an immediate judgment application that should not be done. It's only going for trial, even if it is allowed in the appeal, final outcome coming in my favor is going for a trial. If in a judgment after a trial, hearing both sides, audio altrum partem, principle of natural justice, both parties heard, doesn't mean just heard, sufficiently heard. Then a judgment is coming, then I can understand if conditions are imposed. Here, it's an immediate judgment, summarily decided, both sides are not sufficiently heard, so imposing conditions should not happen, Your Lordship. We should be allowed to appeal After the trial, if a judgment is passed against me, and then if I have to go to appeal, at that stage we can consider that, but not now, Your Lordship. In an immediate judgment application, conditions should not be imposed.
All right, well, thank you. And thank you for your submissions. I thank both of you for your assistance. I will reserve my decision and deliver it as soon as I am able to. So thank you, and thank you to the court staff. That now ends this hearing.
Well, one brief point, my lord, which is that if you'd like to see Justice Martin's decision, we'll send it to you.
Oh yes, please.
Yes, we'll send it to you. It's paragraphs 200 and 201, where he explains his reasons for allowing Dr. Shetty to contest the signature point. I should also observe that although a number of legal arguments were taken there, they didn't overlap. They were different from the points taken here, and they were all rejected by Justice Martin as hopeless. But anyway, it's quite an entertaining read. So we'll pass that on to you.
Thank you for your help again.
Thank you.
All right, thank you. That now ends this hearing.